Colleagues, thank you very much. Today we're starting bill hearings. I believe we're starting with Bill 520, which Delegate Johnson. Again, and I want to caution all of my colleagues from the members of the House Economic Matters Committee, please, when you can, show up on time, and when you can't, let us know. It looks like there's already a question, which is great. In fact, I think several people have questions for the delegate. They're just messing with you. This is your first time presenting, right? In front of Economic Matters? I don't think that, well, the first bill didn't pass, so that probably doesn't count.
This one won't either.
Well, we just wanted to give you again, so thank you. Do you have a panel? I see Bill Castelli. Bill, if you want to come on up. And I'm sure you're getting ready to move us with some incredible testimony, so thank you. Thank you, sir. I'm looking forward to it.
Good afternoon, Chair, Vice Chair, members of my wonderful committee. For the record, my name is Delegate Andre Johnson. I'm here to testify in support of HB 520, and I'm going to ask for a favorable report, which addresses the complaints against real estate licensees to the Maryland Real Estate Commission. Why are we here today? The current law requires that all complaints against real estate licensees be made under oath. So people are required to give their information so that the Real Estate Commission can take action. This means that the commission that receives the information, it receives evidence of violations without complainant's names. The commission cannot take action against that particular person. So this bill addresses that, Mr. Chair and committee. It addresses it in a way that the commission can act on anonymous complaints of violations related to advertising. Now I'll turn it over to my panel so that they can address it further.
Thank you, members of the committee. Mr. Chairman, Bill Castelli on behalf of the Maryland Realtors. And we are in support of the bill. I want to thank the delegate for sponsoring the legislation. And what it really does is just for advertising violations where there is actual physical evidence of the violation itself. So you have the advertisement, it might be a paper advertisement, it violates the statute, that there can be, the commission can still proceed with an action. And a lot of times it's a cease and desist. They notify the licensee, hey, you're not in compliance with the advertising regulations, please correct it. So this doesn't remove any of the ability of the agent to say, you know, I didn't place it. So they still have all the ability to go before the commission and defend themselves to it. But it would allow the commission to move forward in those events where the advertisement was faxed into them. So we would encourage a favorable report.
It's definitely an earth-shaking bill, Delegate. I think we're moving mountains one pebble at a time. But again, I don't see any questions. Bill, thank you very much for coming to testify in my committee. We'll move on to the next bill. Thank you guys very much.
Thank you.
Next bill is House Bill 251. I believe we have fine, Larry's. And Andrew, you have a panel or are you just winging it? You got it?
Just winging it, yeah.
Got it, brother.
Thank you, Mr. Chairman. Good afternoon, Economic Matters Committee members. For the record, Andrew Fulginiti with the Maryland Department of Labor, here to present and in support of House Bill 251. So this bill addresses a very specific problem that arose during the pandemic. What the bill does is it clarifies how the standard of reasonable assurance is applied in our statute when determining a claimant's eligibility. So what does that actually mean and who does it impact? So reasonable assurance is typically used when we're talking about employees of educational institutions. So we're talking about teachers, cafeteria workers, bus drivers. Generally, those employees are ineligible for a UI claim during summer based on what's called reasonable assurance, right? The reasonable assurance that they will return to work in the next successive term. In contrast, the department has interpreted the law to provide that individuals engaged in employment for for-profit organizations do not have the same reasonable assurance. And therefore, during those summer months, they typically apply and are eligible for unemployment insurance. Again, the most relatable example to use here is school bus drivers. A lot of jurisdictions, probably many of yours, contract out bus driver and student transportation services. So those drivers during the summer months are very familiar with this process. They often file UI claims, and notwithstanding any other eligibility issues, are often eligible for unemployment insurance. During the pandemic, what happened is, the federal government gave states flexibility to use outside non-merit staff to start processing claims and make determinations. And the way we had at the department interpreted and applied that statute was applied in the reverse. So this bill really is just seeking to clarify the interpretation of what reasonable assurance is and make that distinction clear in the statute. With that, I'll close and thank the committee and ask for a favorable report.
Apologize for the clock going off, buddy.
No
I hope you're
worries.
panicking, but you seem like you did a great job. I don't see any questions. You have one favorable, but it says testifying none. Is there a Lee Hudson in the room? Okay, and then you can go ahead and step back, Andrew.
right.
I think we got it. And
Thank
then
you.
we also have Leslie Volkmar, Barbara Hopkins, and Heather Ben-Jamison. And I'll say they are all have unfavorable, but testifying as none. So apparently they're not here. All right, well, I guess that ends this hearing as well. Thank you very much. Moving on to the next bill, which is House Bill 261. Delegate Plavkovich Carr, do you have a panel, ma'am? Can you please call them?
I just have one witness, David Garris. He's welcome to come up if he's
Is he
in.
here? Mr. Garris,
I don't see him, but I'll just go ahead and go.
please.
So,
Thank you.
Good afternoon. For the record, I'm Delegate Julie Plavkovich Carr, here to present House Bill 261. This bill takes an innovative approach to addressing our state's chronic shortage of election judges. Just last week, Washington County's Herald Mail newspaper published an article with the headline, "Needed for Maryland Primary, 200 election judges for Washington. Can you help?" Local boards of elections across our state are similarly scrambling to recruit enough workers to fill this essential role in our democracy. And this has been the case for several election cycles. The General Assembly has acted repeatedly to tackle this shortage of election judges, including increasing minimum election judge pay, requiring the State Board of Elections to develop a marketing campaign, establishing an election day page program to recruit youth, and incentivizing state employees to serve. Yet we still don't have enough election judges. HB 261 would add to this list of recruitment strategies by tapping into the unemployed labor force. Specifically, the bill would exempt the stipend election judges are paid from unemployment benefits. The bill would also prevent UI recipients from being disqualified from their benefits because of their temporary service as an election judge. The bill mirrors existing UI protections in state law for jury duty. Other states have taken similar action, including Colorado, Nebraska, New Jersey, North Carolina, New York, and Minnesota. An additional 7 states have a high enough threshold for their weekly income disregard that a person earning Maryland's election judge stipend would not experience adverse effects on their UI benefits in those states. In sum, this bill will help to recruit more election judges while benefiting out-of-work Marylanders who could earn some extra money by serving in this temporary civic role. Notably, the Department of Labor is in support of the bill and believes that the impacts to the UI Trust Fund would be de minimis. Thank you for your consideration.
Has your person arrived, Mr. Darius?
Yeah.
David?
I don't see him.
Okay, I just want to make sure. Thank you for your presentation. I do not see any questions, so thank you very much. That concludes this bill hearing.
Thank you.
Good. Moving on, the next bill hearing, House Bill 197. Come up, Ms. Braun.
Yes,
Do you have a panel, ma'am? Or just yourself?
just me.
Okay. Go ahead, you may begin.
Good afternoon. The record, I'm Alexis Braun with the Maryland Department of Labor. We're here to testify today in support of HB 197. There are approximately 140,000 federal civilian employees with work sites in Maryland. Of those employees, approximately 35 would be furloughed in the case of a federal government shutdown. Those individuals are eligible for unemployment compensation for federal employees, UCFE benefits from the department during a federal government shutdown, but they are held to the same requirements as other UI recipients, including, and most relevant to this bill, the requirement that they be actively seeking work. Unique to these claimants is that they may be subject to certain standards of ethical conduct when they're furloughed, including rules regarding outside employment and seeking outside employment. Maryland law permits a Secretary of Labor to exempt certain claimants from active search for work requirement, but it does not include a specific provision which exempts these furloughed federal civilian employees from the requirement during a full or partial government shutdown, even though they're similarly situated to some that do have an exemption. This bill would expressly permit the Secretary of Labor to waive that active search for work requirement for furloughed federal civilian employees during a full or partial government shutdown due to a lapse in appropriations. This would have a positive operational impact on the agency by easing the administrative burden on the division during federal shutdowns and allow the division to more easily and quickly provide benefits to federal civilian employees affected by the shutdown who remain work attached. The department does not anticipate any impact on expenditures or revenues as a result of the bill and asks for a favorable report from the committee.
So I understand that it seems like every other week there's a government shutdown at the federal level happening, but when it goes through, there's back pay to those federal employees, correct?
Yes.
Okay, that's all I need to know. Thank you.
Seeing no further questions, I believe we'll move on to, we have, again, the text says Nelda Fink. I say none, so I guess they're not. We have one virtual witness, Sheena Cross, not in. Yep. All right, well, thank you very much. That does conclude this bill hearing. Next bill, House Bill 360. It's on behalf of the Prince George's County delegation, Mike O'Halloran, Sarah Price. Oops, no, I take that back. I'm sorry. Don't you guys come up yet. You guys are against it. Gotcha. I should have known. I've never seen y'all say yes to anything, so. Is there anybody here from the Prince George's County delegation ready to present this bill? Okay, we'll pass this bill for now. Right? Might do your job for you guys. So next we move to House Bill 419. Delegate Lehman. Outstanding. All right. I need somebody to please reach out to let Joy know what about House Bills 360 and 419. There's nobody here.
Who's the chair of the Prince George's?
I guess we're going to move on for now to House Bill 339 is Delegate Vogel. There you go. Outstanding. You have a panel, sir?
I do, sir.
Go ahead and introduce them as well.
Mr. Chairman, Mr. Vice Chair, and members of the House Economic Matters Committee, thank you so much for your consideration of this bill. Under current law, an individual is disqualified from receiving unemployment benefits if they are unemployed as a result of a stoppage of work because of a labor dispute. House Bill 339 would establish that this disqualification would not apply after 14 days of the stoppage. Workers who are striking as part of a collective bargaining effort would prefer to be at work, not claiming unemployment benefits. When working conditions are unacceptable and compensation contracts are unfair, workers should have the right to fairly collectively bargain. Strikes are a tactic of last resort, but a necessary right to level the playing field for workers. During a strike, corporate executives continue to make an income while workers do not, compromising their ability to reach a fair deal. It is important that workers during a labor dispute can continue to afford their rent, groceries, and other basic necessities. By removing this disqualification after 14 days, workers forego 2 weeks of wages, then individuals otherwise eligible to receive unemployment benefits can receive them thereafter. Given that unemployment benefits cover the bare minimum of one's needs and cannot alone provide significant quality of life, allowing workers to claim unemployment after 2 weeks would not disincentivize reaching a satisfactory agreement in a timely manner. But with this legislation, workers who are on strike would not have to choose between long-term fair pay and fair working conditions and their short-term ability to support themselves and their families. It is for this reason that I urge this committee to give a favorable report to House Bill 339. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. I'm Donna Edwards. I'm president of the Maryland State and DC AFL-CIO. We urge your support for House Bill 339. This is not new. In New York, as well as New Jersey, they both do this now. Pennsylvania works with our striking employees to provide unemployment at certain instances. And if there is the right to strike, then that is protected by law. Then there should be also the right to receive your unemployment benefits after a wait period when you are on strike. So we really recommend that Maryland start to join the ranks of the states that are considering this. Washington, Pennsylvania, Massachusetts, Connecticut, we're all moving forward this way. So thank you, and we urge your favorable report.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Sam Epps, the political director with Unite Here Local 25. We represent hospitality workers in Prince George's County, Montgomery County. And we are here in support of House Bill 339. We believe that workers should have a right to collect unemployment, and we ditto everything our State Fed President Donna Edwards said. And we do have a worker here from Local 25 that will speak to this bill in favor. Thank you, Ms. Chair.
Hi, good afternoon and happy Valentine's Day, Chair, Vice Chair, and members of the committee. I'm Lisa Smith. I'm from Montgomery County. I work for Hilton Hotels, where I am a shop steward and a proud member of Unite Here Local 25. I'm testifying on behalf of hardworking hotel, restaurant, and casino workers in Maryland. I want to express our strong support for Bill HB 0339, recognizing the need of fairness, compassion in a time of labor dispute. As a union worker, I know the value of having a voice in the workplace and the impact on myself, my son, my community. Our union job allows us to volunteer and serve our community, all the while providing us essential health benefits and a livable wage. However, our contract negotiation approaches. The possibility of a strike looms, and the critical consideration for the workers in our community is important. HB 0339 brings a much needed change by ensuring that individuals impacted by labor disputes are not disqualified from receiving unemployment insurance benefits after the initial 14 days of unemployment. This is important provision recognize that hardship faced by workers, particularly those living paycheck by paycheck or have limited resource. By supporting this bill, you are safeguarding the livelihood of thousands of hardworking individuals who contribute to the success of our community. You are making a statement that we should not punish workers for exercising their rights to bring bargain collective for a fair working condition and wages. I urge the committee to stand with workers and support HB 0339 with a favorable report. This creates an environment of fairness, compassion, and an understanding for all workers in Maryland. Thank you.
Thank you, Mr. Chair. So to the bill sponsor, The rationale behind this is to grant people the benefits of unemployment insurance, but this isn't exactly, they're unemployed, they're in the middle of a strike, so there is a push and pull that relates to a labor difficulty that forces both parties to come to the table. I guess really my only question to the bill sponsor, not to get into the weeds on this, but do you think this helps bring parties to the table, or do you think this grants extended time for which someone can strike, groups of people can strike, and actually does quite the opposite of what should happen during these points of conflict?
Thank you for the question, Delegate. And I would say that this bill evens the playing field. Because right now, corporate executives or employers are still continuing to make an income during a strike. But what we're seeing is that workers are being starved until the point where they have to agree to unfair terms of a contract. So this would ensure that if you're looking at both sides of an agreement during a collective bargaining effort, this would ensure that workers are getting paid just like employers are.
Okay. Donna, good to see you.
Good to see you. Thank you. Happy Valentine's Day.
I guess I look at this bill and I have a little bit of a problem with it. You say it's unfair and all that. I think what the delegate was mentioning about encouragement, I think it's very much there. We do a lot in this committee for unions. We make sure you're getting paid the wages you're currently looking for, prevailing wage. We try to accommodate a lot of it. We've given you benefits beyond what we give a lot of other people that own their own businesses. And my comment is coming back. I think this is a little unfair, and I think it will encourage a longer strike period. And I do think that by being in a union, you know, I would call that more a failure of leadership on both sides. And I think that the union bears a lot of responsibility for this to either be more reasonable or less reasonable, however it will dictate. But don't forget that while this work stoppage does stop, the business is being hurt too. Wouldn't you agree?
Is that my question?
No, it's anybody's question. I'm
Gonna go for it.
I would disagree. And because honestly, we pay so little in even our maximum payout of UI that it is not going to stop anybody from wanting to go back to the table and really get to work at the wages that they were earning and what they're asking for. Secondly, every dime of an unemployment check goes back into the local and state economy. It's not enough. It's just going to pay your bills or to try to have stoppage from being cut off from your heat and electricity, et cetera. So I think that it's unfair because in your statement, I actually did hear that, you know, it really allows for the corporation to try to starve us out and move workers back into taking less than what we may be able to do at a bargaining table.
Well, you know, there's other bills in here to exponentially increase unemployment. So
Yes.
this is not what I mean, it's moving
No.
in a direction at this point. But I just see it as really something that I'm choosing. I don't have that benefit to quit working because I don't think I'm making enough money. I don't have that as a person working for someone. I don't have that. If I quit my job, if I don't like what I'm getting, I need to find another job. And that's kind of what the world has always been like. That if you don't like what you're getting, you could do that. And I don't see putting the responsibility on UI, which is already heavily burdened. When you increase your rates, you increase everybody's rates. And the smaller business, I think, are going to be harmed by this. It's just a statement. Thank you very much. Thank you.
Thank you. Good afternoon. Question is so the bill reads up to 14 days of receiving unemployment insurance, or is it beyond that?
You have to be on strike for 14 days.
You have to be, okay, I just wanted to clarify. I was reading it and I just wasn't sure. So you would be on strike for up to 14 days, after which point you would be receiving unemployment benefits. So how often do you folks go on strike? You know, name any given union that you represent.
Actually, I can give you the thought for 2022 and 2023, there's only been 2 strikes that went over 14 days.
Okay.
Okay, and that was at the Mack Truck, which you all are aware of,
Mhm.
and Sherwin-Williams also.
Okay. And when you guys do decide to go on strike, since you're a union and people
I guess presumably are required to belong to it. But what are the union dues used for?
There are unions do have strike funds,
To pay.
some of them,
To pay
yeah.
the union members.
to try to help, stay the same way any charitable organization does in order to help families out to
Okay.
maintain.
So you do have funds that you use from collecting dues
Some
from the
unions do.
members
Some unions
to
do,
pay them when they go on strike.
some
Okay.
unions do, not
So,
all unions. Not every union, but some unions do,
is that right?
yes.
So then why is this necessary for those that already do?
Because this is something that they have been paying into and they're not going on, no one goes out on strike because you want to. That is the absolute last resort. The absolute last resort. And you've already paid into your unemployment. For the time that you are on strike, the business is not paying your salary or any of those costs. And so this is something that is available through what you have paid into it as well as the business. And it just kind of helps people from the economy, from losing their house and small businesses from not being able to have a pizza, that kind of thing.
No, I mean, I think this is a good discussion because it seems like what you're doing is you're collecting dues from members for the purpose of when it's needed for when the people go on strike for representation. But then with this bill, you're cost shifting. You're essentially saying we're going to collect dues, but we're also going to have the state taxpayers pay for it, even though we're collecting dues. So it seems like it should be one or the other.
I'm not necessarily sure that unemployment insurance is taxpayer, it's business and workers paying for it. So, and I understand how you see it.
Yeah, okay.
Thank you for those
Thank you.
questions.
Thank you, Mr. Chairman. My question is related to the letter from the Department of Labor, where they had the informational letter that talked to some types of operational concerns with implementing this. So I wanted to see if you had some insight into what those were. I can assume one could be similar to what we just heard with the federal shutdown, that they wouldn't be required to actively look for work because they already are, they have a job once they settle the strikes. But do you have any other insights into what these other operational issues may be from the Department of Labor?
So thank you for that question, Delegate. And it's exactly the point that you're making. So we have an amendment that is very similar language to the bill that you all were considering earlier for furloughed workers that would, and we're having active conversations with the Department of Labor and with folks at the federal level to figure out where the preemption lies. But obviously, if you're a worker that's in the midst of a labor dispute, you shouldn't be having to search for new work to qualify for unemployment benefits. So we have an amendment that would make that adjustment.
And that's the only operational ones we're aware of, issues that they're concerned about?
That's the principal challenge, and just figuring out where that where the eligibility criteria is set by state statute, state regulation, or federal policy.
Okay, thank you.
Thank you, Mr. Chairman. So I guess to tag on to what Delegate Fisher was asking, how would this work if you have a union member who is receiving benefits from the union? Would the unemployment benefits be reduced by the payment from the union, or because I think now if you make over a certain amount of money, you don't qualify, correct?
We can take an example. It is when the cost of a worker, like you said, if they're out, they're furloughed, they get a part-time job, but they're collecting their unemployment. We have this right now with hospitality workers. We have a slow season, right? No one comes into our hotels in December, January. Our kickoff happens in March. So many of our workers don't have the hours, the 40 hours a week, so they go on unemployment. But some also take a part-time job and still collect unemployment, but they subtract that amount in the unemployment benefit to meet what they would be receiving on unemployment. So it subtracts out whatever they're making.
So the payment from the union considered a wage, and it would be reduced.
Yes.
The unemployment.
See no more. Is Andrew still here? Very good. Now you're. So thank you guys very much, the panel. Andrew, could you come
Thank
up
you
for a
so
few
much.
questions, please?
I'm gonna bring up our policy.
That's fine. I'm not trying to catch you slipping, buddy. But because I do have a few questions since we're discussing this. And I'd like you to briefly explain because, and I need the body to hear this. How our table works when it comes to unemployment, because we have a fund, correct?
We do.
And that fund is funded by employers, correct?
Correct.
And there's a rating system, isn't there, regardless of the table you're in, correct?
Correct.
I'm sorry, let me step out of the court thing. There's a rating system, okay? To my understanding, the more claims you have against you, the higher your rating goes. And as a business, the more you have to pay. I understand that correct?
That's correct.
And it can go up substantially depending on how many people file a claim, even for a short period. Do they regulate? Did you get a little like wiggle room if it's just a month or 4 months of a claim, or is it just a claim as a claim?
I believe it's a claim as a.
I believe a
yeah.
claim is a claim.
Yeah.
Yeah, and I just want to make sure. So I guess that's my concern when we're talking about this legislation that we just heard is it is almost a double whammy because now you're really putting that business because now all these claims, I watched my wife's claims go from $53 per year to $1,870 per employee because it was a bad time and people lost their jobs. And on this one, I think it's the way we currently set things up is regardless of, why the unemployment is collected, it is paid for by the employer. And I'm worried that now we are creating a weird balance where they know the more people that step out and go on strike, and regardless if they come back and they work this all out, and regardless whether the union members can get back pay from their union dues, the employer will be stuck at a different rating scale, depending on the number of claims. Isn't that correct?
That's correct.
And I just want to make sure I'm not missing anything because there are always two sides to everything. There's always impacts. And it sounds like a possible unintended consequence, Delegate Vogel, is that you're now putting these employers in a very precarious position because now they'll be like we talked before about how somebody's searching, worried about paying their bills. Now they have to worry about, oh my God, am I going to be stuck at this astronomical fee per person? And Andrew, when somebody makes a claim, how long are you stuck in that rating? Is it as far as like when does it count back to zero?
The rating is assigned every year.
Right. So for the rest of the year, they're going to be stuck at whatever that rating is. And I think that's it sounds like a horrible imbalance. And it's another basically threat that's like, look, if we all leave, you're going to be paying a larger amount than you've ever paid before because of a discrepancy with the contract. And I just wanted to make sure everybody listening understood that that's the way the the unemployment system works. So when they step out for to go on strike, then it's not only that is that business not making money because obviously they can't produce or not being productive, but they also are now for the next year going to be stuck at a different pace or a rating system. And it could be very high depending on what scale we're in. And I want to make sure I'm not missing anything because that's what I heard when I heard this bill is the other side of that coin that wasn't spoken about. I'm not asking you to, lock yourself in. I don't need you to agree on the bill. I just want to make sure I'm not missing that. So thank you guys very much. I didn't know if there were any other questions. Of course, Chris, I'm playing. Go ahead, sir.
Thank you, Chairman. So Andrew, there are work search requirements under unemployment insurance, which means that if somebody goes on unemployment insurance, almost immediately, their job is to find another job. So in this bill, we're not changing, quote unquote, the work search requirements, are we?
The bill does not affect that.
Okay,
no.
I mean, so the other inequity here is that unemployment insurance, I brought this up with the bill sponsor. I mean, there's some tangle here that doesn't seem to mesh, but it really goes outside of what unemployment insurance and its definition even is. So I guess my last question is if we don't have work search requirements, which is an obligation of the person who's on unemployment insurance, how do we encourage the people to use unemployment insurance for how it's intended, which is to use it only when needed? And maybe that's asking a political question of a policymaker, but maybe I should stop there because I think I've answered my question. This bill doesn't speak to the things that unemployment insurance is at its base. We may, as a committee, agree to do something, but it's not an unemployment insurance question. It's are we compassionate to this idea that people, when they go on strike, need to get compensation, but that compensation doesn't feel like unemployment insurance. You may agree or disagree or take no comment, so I'll leave it there. All right.
That's fine.
I believe that does conclude this bill hearing. I want to go back to Prince George County Delegation, House Bill 360. Wait, whoa. Hold on, Senator. We have some protocol issues here. Yeah, you know you're not a member of the House anymore. I just want to make sure you understood. You quit. So yeah, you have to sit down. We're gonna have Andrew. Do you want to go ahead and take this form? He can, yeah. You'll have your time after crossover, buddy.
This is 360, right? Good afternoon, members of Mr. Chair, Mr. Vice Chair, members of the House Economic Matters Committee. For the record, I'm Delegate Andrea Fletcher at Harrison. And I am sitting in right now as the Vice Chair of the Prince George's delegation. We have before us HB 360, retail service station dealers. Basically, this bill is to have full service attendance at gas stations. We've had, we all know about all of the increase in crime, particularly at gas stations. And so by having full service attendance, as we did back in perhaps the 70s, some of us here may not know about that. I do though. We believe that it may provide for a safer experience for our residents who are attempting to fill their tanks. And so with that, I'm going to turn it over to the chair of the Prince George's delegation.
And thank you for stepping in and keeping it moving. You did a great job. You can go back to your seat.
Thank you so much, Chair Wilson, Vice Chair Crosby, and the wonderful members of the Economic Matters Committee. I apologize for the tardiness, but I am Delegate Nicole Williams, Chair of the Prince George's County House Delegation, here on the bill that is in front of you. And so this is a bill, the delegation is planning on taking up this bill next week. And so hopefully we will be able to provide the committee with a letter from the delegation with regards to this piece of legislation. But this bill was really brought with regards to concern of safety for our seniors. As you all may hear in your own respective districts about the unfortunate uptick that we are anecdotally seeing as it relates to carjackings. Prince George's County, unfortunately, we are not immune to that. And we are really concerned about the safety and welfare of our most vulnerable populations within our county, which is why this bill was put forth before the delegation. The impetus of this bill is to provide a mechanism where our seniors will not have to get out of their vehicle in order to pump their gas if they happen to be out late at night, heaven forbid. You know, folks need to get their gas after prayer service on Tuesday evenings. And so it would allow full service during a limited time period. We do not want to create a hardship for our gas service owners within our county. And so therefore, we want to provide an opportunity to protect our seniors, but that's also balanced with the business community within Prince George's County. And that's what this bill is seeking to do. There are some amendments that will be forthcoming as well to really emphasize the concerns that we heard from the business owners of gas stations within our county to address their concerns. And hopefully we will be able to get those amendments to you very quickly forthcoming. But that is really the reason that this bill was brought forth before our delegation in an effort to really provide a safety mechanism for our seniors who just so happen to be out late, but still need to get gas and do all of the other things, but really do not want to impact their safety in the process. So thank you.
I do have a few questions.
Sure.
Again, this bill did catch my eye because I noticed 6 a.m. to midnight, and it didn't say may, it said shall, as in every service station. So it sounds like every service station is going to have to hire extra people because, you know, when you go to some, especially, and I think we're missing a very valid point here is they're people too. The
I understand.
people working and pumping the gas who now also not only are outside to the elements and whatever and exposed to the crime, because I'm a defense attorney, are also now more likely to be victimized. Now, granted, they're not going to be carjacked, but they have access to the inside. They have access to the safe. They have to come out. And to me, it sounds almost terrifying to mandate people to work in this position. And I don't want to quote, because a lot of people say this every time they come to my committee, but it's going to be a lot of Black and brown people working those jobs. And I'm saying that should have been funny to everybody because they keep saying that to us. But
Understood,
literally,
Mr. Chair.
we're really setting up what I would consider victims who are going to be, because it's not that somebody's pumping gas. They're now the person who has to come out, who has access to the inside, where the cash is, where the safe is, where the food is. And we're saying, no, you have to have somebody that not only has access to the inside, but they have to come out and expose themselves. And that sounds downright terrifying. So as you guys go through, I want you to understand my consternation. Nobody's life is worth any more than others. And I appreciate you protecting seniors. I get that. That's why I keep talking about being a little tougher on crime. This isn't a committee for that, unless we're trying to apparently throw business owners in jail. But
No, not at all.
But no, I would really, really hope that you look at who you're talking about. And they're going to be there, and they're going to be the ones who definitely are exposing themselves to be victims for what I will definitely consider minimum wage.
Understood.
And I mean, so please, the shall thing really did catch me off guard because they can already do it. I believe they can. And I think marketing, if that's what you wanted to be, hey, we have full service here. You can always drive a few extra miles and we'll take care of you. I think somebody, if they saw that as a viable money-making deal, would have jumped on it. So I'm very concerned with who we might be setting up as victims. But thank you very much for your presentation.
Thank you. Thank you so much, Mr. Chair.
Thank you, Mr. Chair. Real quick, Delegate, this is similar to what New Jersey has, correct?
That is correct.
Okay.
Though New Jersey's model is 24/7, if I recall correctly, they have full service gas available anytime throughout the day. I think the goal with this bill is just to limit the duration of the time in which full service gas to just those evening hours. Again, part of what we're trying to do is not create a hardship for our gas station owners within our county. And so therefore there is a limitation of the time period.
Yep. And so I guess if the intent is to prevent carjackings, I'm curious, like the stats that I'm looking at right now, the carjackings are actually higher in New Jersey than they are in Maryland.
Oh, wow.
So I'm just curious,
Well,
maybe there's updated data that we could get together and see if we.
yeah, I mean, I'm not a representative for the New Jersey General Assembly, so I wasn't familiar with that statistic.
Okay.
But yes,
Thank you.
thank you.
Delegate Queen.
Thank you, Mr. Chair. This is an interesting bill to me because just New Year's Eve on a Sunday at 11:30 a.m., I went to a gas station and went to pay for my gas inside, and within 5 minutes, my car was broken into and stuff was stolen. So they're very quick. I don't care how many people would have been around, but everybody told me, well, you were lucky because you weren't in the car because they would have carjacked it or whatever. So in this discussion, did you talk about maybe having more police presence at a gas station versus having employees be put at risk? That seems to be a that would have made me feel safe and maybe have deterred someone from breaking in my car when I went to go pay for it. Has anybody thought about that?
Yeah, that is a very excellent point, Delegate Queen. And like I said, we are going to take up this matter next week within our delegation. And so I will make sure that that is part of the discussion as we are discussing our support for this particular piece of legislation.
Okay, you don't have to explain your.
Oh, I absolutely understand. I had a somewhat similar experience just a year ago when I went to the dentist and was just only in for 15 minutes and came back out, and the someone had broken into my own vehicle and stolen some items out of my vehicle. So I definitely understand the feeling, how violated one feels whenever that happens to them. So I am very sympathetic to that.
Well, I want to say thank you again for presenting. It sounds like this is some insane senator's bill that you just happened to carry, so I appreciate that. But I did want to say thank you, but thank you very much. I do hope you did hear my issues.
Oh, absolutely. We
Please.
heard you very loud and clear,
Thank you
Mr.
very
Chair.
much.
We will definitely consider those remarks and pointed items that you mentioned in our conversations when we take this up next week as a delegation.
And thank you very much. Have a
All
wonderful
righty.
day.
Thank you. All right. Bye-bye. If there aren't any more questions. Nope. Okay.
That's my line.
Okay.
House Bill 419, Delegate Lehman.
Mr. Chair, if I could bring up my panel, Mr. Epps and Mr. Lucci. Thank you. And I do have two slides to illustrate this bill. They're very simple. So with that, I'm going to get started. Good afternoon, Mr. Chair, Mr. Vice Chair, and esteemed Economic Matters Committee members. For the record, I am Delegate Mary Lehman, and I'm here asking for your favorable consideration of House Bill 419, Automatic Tipped Screen Prompt. More and more eateries and other service-related businesses are asking customers if they would like to add a tip at the point of sale. Prior to COVID, tips for food and beverage services were more often associated with sit-down restaurants. And that, of course, is where a customer can voluntarily add a tip to his or her bill. But now coffee shops, ice cream stores, bakeries, delis, convenience stores, and other venues are asking customers whether they want to add a tip for takeout food and beverages. Technology has played an important role in facilitating tipping requests at the end of such transactions. The most common scenario occurs when a cashier either flips a screen tablet over for the customer to see or turns a screen around for you to sign for your purchase, and then an option to tip pops up. So these screens rarely specify to whom the tip is going. This is what you would typically see. Would you like to add a tip? You'll see your bill displayed at the top. In this case, it's $34.40. And then you're just asked, do you want to add 15, 20, 18? You can add a custom tip or you can add no tip. So that's what you most often will see. HB 419 is an attempt to require transparency and inform consumers about whom they are tipping. The bill requires a simple sentence or a phrase on the same pay screen that offers a choice of your tipping levels, clearly stating who would receive the tip. For example, it might say, do you want to tip the barista? Do you want to tip the sandwich maker? Or simply, do you want to tip the staff? Panera does this. It's one of the only businesses I have seen that does this. And it does it, as you can see, this is an actual screen from inside a Panera store. And as an aside, Panera asks, rather than a percentage, it says, would you like to tip your bakery cafe team? And again, you're given options. In this case, it's dollar figures, 50 cents, $1, $2, other, or no tip. So in summary, this bill is about wages and labor, but it's also a consumer issue. And I would encourage you to read the favorable written testimony from the Consumer Protection Division of the Attorney General's Office. It's a letter in support of the bill, and it notes that the Federal Trade Commission has actually taken action against businesses that misled consumers about the purpose of their tips by diverting them from the employees and instead using tips to defray their overhead costs. In 2021, Amazon Flex paid more than $61 million to settle an FTC complaint that it failed to provide its drivers the full amount of tips they received over a 2.5-year period. I want to emphasize that this bill does not require a tip. It just says to whom the tip will be allocated, thereby allowing consumers to make an educated decision about whether and how much they want to tip. Mr. Chairman, I just want to share with all of you anecdotally, I have been asking this question for more than a year wherever I go in the state of Maryland. If I am asked a tip at the point of sale, I make a point of asking the person in front of me and any other employees around them who is getting these tips. With almost no exceptions. The workers say, we never see them. We do not get those tips. I will tell you where the exceptions happen. In corporate stores like Panera and in Starbucks, where the employees consistently say at the end of a shift, whatever tips were put into the register, those are divided evenly between all of the hourly staff and they are added to our paychecks. In franchises like Dunkin' Donuts and Subway and mom and pop stores, I have yet to talk to one worker who said we get those tips. The workers, the hourly workers are not seeing these tips. And so I would ask you to consider that and request a favorable report of House Bill 419. Thank you.
Thank you, Mr. Chairman. Again, for the record, Sam Epps, Political Director with Unite Here, Local 25. We represent about 2,500 members in Prince George's County, Maryland. Many of them are tip workers, from food and beverage to cashiers in our hotels, restaurants that we represent those workers at. We are here to, we think this bill is very simple and straightforward. We think it does three things. It helps the business, the consumer, and it does not, it also decreases what we call wage theft, right? And as Delegate Lehman pointed out, that many of these workers do not see the tips that don't have specific transparency on it. And so we are here in today to support this. We believe that just simple transparency, who the tip goes to, it also helps on the back end where workers who are in the tip wages classifications, at the end of the week, they can see where the makeup is and where the business then have to make up their wages to get to the tip wage hourly rate. So we hope that this committee would provide a favorable report to this House Bill 419.
Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chairman. It's an honor to be before all of you this afternoon. My name is Len Lucci. I'm an attorney here on behalf of the organization One Fair Wage in support of House Bill 419. This bill is a basic common sense consumer protection provision by enforcing disclosure of where the money goes. It does not cast any judgment on whether the tipping is a good thing or a bad thing, just that if you spend the money on the tip that you know where the money is going to go to. And for that reason, I'm here in support of the bill.
Delegate Queen.
Thank you, Mr. Chairman. This one gets, I can understand the issue about wage tip theft, but I guess I'm kind of confused because if I'm doing a paper tip and I give the tip, it doesn't tell me where it's going. I mean, I could have the same problem with that sort of method. So I guess I'm not sure how this would change an employer who's stealing tips from their employees. How would this help that?
So very good question, Delegate Queen. In our industry, when that happens, many of them are point of service. You receive the book and you have the tip line there. At the end of their shift, when they're changing the shift, they have to reconcile their drawer. And under our contracts, those members, as delegates, it's a pooling system. So even if you're a bartender, all the tips off of that in our drawer goes to all those workers who worked on that shift in the classification. Right. The bar attendant, the server who are doing tabletops right across from the bars, it is then split like that in a pooling system. So that's how they know at the end of the shift with the reconciliation of their drawer.
And so they don't know that with the point of sale one that they bring to the table?
Well, as you can see, some of them at some of the franchises don't have that, or some they just put it in and it just at the end of the shift, the hourly workers don't receive that.
Well, so I was just at Busboys and Poets
Mhm.
this past Saturday.
Mhm.
And the young lady that was there who came there and she came and says, I'm getting ready to leave off tips. So I want to settle my bill before you go. Right. So it was like, okay, we'll do that. And we paid her and she had one of those little machines there. She knows we gave her tips because she can see it. How was she not? I mean, I don't see how this bill would change anything. If somebody was going to steal her
It's not
tips,
uniform.
they're gonna
And
steal her
that's what
tips.
we're getting. You're giving uniformity now. So at Busboys, yes. So if you go to a bakery that just turns around the screen and says 30%.
They don't see it.
They don't see it. But if you go as the example that Delegate Lehman gave with Panera, they say give $3 to the bakery team. They see it because it specifically goes to that area.
So the issue is the employees aren't seeing where it goes, not that the patron is not seeing it.
That's
correct.
right.
Correct.
Right.
And Delegate Queen, if I might, I think it's a lot of this issue is around you asked about signing a paper bill and if it's in a restaurant, the server being able to see what you gave. I think this has a lot to do with this technology piece where customers are just, kind of randomly saying, okay, I guess 10% or 15%. And the employees have no real way of tracking that, except in those situations I described. That's anecdotal in these corporate stores where they say, oh yes, we are pooling those tips at the end of a shift. But the other folks I've asked have just said, we never see them. We just don't, they just kind of go into the system and they disappear. I have one really specific quick illustration, Mr. Chair, of being waited on in a Subway store in Howard County, where the sandwich maker, you start at the end of the counter and you tell them what kind of bread you want, what kind of meat, cheese, and so on, all the way down the line. I get to the end to pay. And the woman who made the sandwich stepped back and some other gentleman stepped forward, an older gentleman who I presume to be either the manager or the owner, asked, do you want to add chips and a drink and whatever? And I said, yes. And then the screen, the total pops up, then the screen pops up saying, do you want to add a tip? And I said very loudly, who is getting this tip? He doesn't answer me. I say a second time, who am I tipping? Silence. The woman is standing directly behind him. And so I say, are the workers getting these tips? And she's going, nope, shaking her head, no. And then I said, well, I will not be tipping the house then. Thank you. And he said nothing, as if he didn't, the entire time didn't hear a word I said. This is what I've heard over and over again. It's that lack of the transaction, the actual, I think, partly the physical transaction where people are just hitting a button. I want to add 10 or 15 or 20%. And then the workers have no way of really tracking it. And I think if you read the Attorney General's written testimony from the Consumer Protection Division, there's a great sentence in there saying consumers customarily believe that the tips they pay are a gratuity or extra compensation for the employees who serve them. That is not what is happening at these point of sale with these point of sale tips. It seems to me the majority of the time.
Okay, thanks.
Thank you, Mr. Chair. So I waited tables in college, and what immediately pops in my head, and Delegate Queen kind of touched on it, is for all these years, when you fill out a tip at a restaurant, you're assuming that the waiter that comes before you is getting that tip. But I seem to recall we had this deal where we would share our tips with like busboys and other folks like that. So, I mean, would it make sense? I mean, and I'm not saying I would support this bill. I definitely support the intent of the bill, but would it make sense to just include all tips? So, you have it just point of sale here. What about electronic point of sale? But what about the paper? Why not just, because there's no guarantee, even though we've never thought about it before, apparently, that when you're giving a tip to a waiter in person, you're assuming that that waiter gets the full amount as well. and there's no guarantee that that person's getting that full amount. They could be sharing it. It could be going elsewhere. So what would be the prohibition of that?
Thank you for the question, Delegate Pippi. This bill does not contemplate that. It's trying to respond to a situation that all of us have seen over and over again. And as I've spoken to people over the last 6 months to a year about this, they say the same thing. I've always wondered who's getting those tips. And so I think what you're talking about is another bill. I think, again, the Attorney General's written testimony makes it clear that that by having this disclosure, this potentially would make it actionable by employees who are not in fact seeing any of these tips at all. And it does not address pooling tips, because there are a number of businesses that do that. In the hotel I stay in here in Annapolis, the valet folks pool their tips at the end of the day. So this is not an issue about pooling tips either. This is an issue where it does not seem a lot of hourly workers are getting tips at all. And if I might, Mr. Chair, I actually heard a story from one of my colleagues whose son was working at an ice cream shop, again in Howard County last summer, and the workers weren't even getting the tips that were in the jar on the counter. They never saw the cash tips in the jar on the counter. So this might be more common
So
than
let me ask,
we
this is my
realize.
final question, then I'm done. So let me ask you this. Are you saying that these establishments are expressly telling customers that the tip is for them and then the tip doesn't go to them? Or are you just saying that there's this assumption that the tip is going to them? Because those are two different things. Because if I go to a business like a car wash and they wash the vehicle and there's a box for tips and I put cash in there, I don't know where that goes. I'm assuming it goes to the people that vacuumed the vehicle and whatnot, but I'm not about to pass a law to fine them up to $1,000 if there was no express discussion about who gets the tip. Because it's one thing if they say this individual is getting the tip and then they don't get the tip. That's one thing. But if you're saying there's an assumption that when you tip at Starbucks, that the person who was joking and friendly to you at the window is the one getting the tip, I don't know if we should be fining that establishment for our assumption or
And
misassumption.
I'm not suggesting that. I am asking for disclosure. We in fact do not know where these tips go. We don't know because it
goes
doesn't
to the
say.
business.
I would just submit this. I think it's fair to say that a lot of folks, I agree with the Attorney General in saying consumers are assuming their tips are going to the people who serve them. That may or may not be the case. But I think it's safe to say that if these tip screens said, would you like to tip the management? Would you like to tip the house? Would you like to tip the owner? I'm thinking a lot more customers would check the no tip button.
Thank you.
Yeah, my colleagues have kind of gotten to the area where I'm a little concerned about the language of the bill. The intent is good. I do the same thing when I go out. I always ask, where is this tip going, to verify who I'm actually going to be giving money to. So the question I have around this is, again, the requirement that this bill only touches screen prompting.
Mm-hmm.
What is stopping a business from saying, well, hey, this is the new law, and now I'm going to print every receipt? Why don't they do that?
I'm sorry, what is your question?
So my question is this: you gave your example at Subway, where you had to hit a button, and it created a rift, and you decided not to tip because you didn't get a clear answer. Your bill only requires this for screens.
Mhm.
What I'm saying is, what is stopping businesses who don't want to comply with your law to then start printing all of their receipts now and go away from screens? What I'm saying is, I think the intent of what you're trying to do can be easily circumvented if everyone just starts printing the receipts instead of using the screen. So what I'm saying is, I think if the intent of the bill is to make sure that we're being transparent about who's getting a tip, then I think it should apply to all forms of sales of transactions, because I think the way this is drafted, you know.
Well, I respectfully disagree. I think it should be, if it's a paper system, then maybe there should be disclosure on a piece of paper. Again, that's a different bill. But since people are being asked electronically, push this button, yes or no, 10%, 20%, that is the way you saw with Panera, is where to show people this is who is getting the tip. That's the way to clarify that issue. And by the way, proprietors who don't like this law, if this becomes law, then they can get rid of that tip screen altogether and stop showing
But-
customers, would you like to tip some money?
Right, but-
And not all, I have a Dunkin' Donuts I go to. I live right at the nexus of Howard, Montgomery, and Prince George's counties. I have a Dunkin' Donuts I go to regularly in Montgomery that has no tip screen at all.
Mhm.
So people can do away with the tip screen too.
Yeah, I think at the end of the day, I appreciate the intention of this bill, and I actually want more transparency on where my tips go. I actually really like the idea. I just want to make sure that we're not creating a law that's easily circumvented. We don't want to pass laws in this chamber that tomorrow, if they can make one change at the corporate office, and what we did here isn't worth it. So I just want to make sure we're thinking about it all the way through. That's all I'm concerned about. So
Thank you.
Thank you. Just a couple of questions. You'd mentioned, what it says in the bill, it says point of sale system. And I know Delegate Pippy, excuse me, did. Oh, boy, Pippy, I don't know. He mentioned the point of sale system, and you mentioned Starbucks and Panera and stuff like that. Is Panera, they would be covered under this as well?
Yes, anyone I mentioned those two to be clear, Delegate Fisher, because in asking all over the state, wherever I go, when I'm asked to tip at a point of sale, what I have heard consistently, the two exceptions to employees saying, we have no idea where these go to, we just don't, we don't get them. That's all we can tell you, is that at Panera stores and at Starbucks, which are both corporate,
I got you.
that this is obviously a corporate policy of Panera that, in fact, probably the earlier part of last year,
No,
I thought about bringing this bill last year. And Panera
my
didn't
answer.
used to have the disclosure screen. They
I got
added
my
it
answer for
sometime
that.
last summer.
But a point of sale system, but it doesn't apply to a restaurant. Like a sit down restaurant where you get service, does it apply there too?
If they use it, it would, but typically they don't, because you get the, bill given to you in paper form.
Most restaurants are
typically.
using those little mobile devices, and you put your credit card in, it gives you an option of 18, 20, 22, or other.
Right.
So it would apply to them, wouldn't it?
Yes, anyone that uses a screen.
So it applies to them as well.
Right, yes.
So what you're saying then is when a waiter brings you, when a waiter is serving you in a sit-down restaurant, which is a wonderful thing,
Mhm.
and you tip that waiter, you're saying you don't think that tip's going to that waiter? That's what your bill is saying.
It says to disclose, would you like to tip the wait staff? It is a simple solution. It's not even technically a full sentence. I know the Restaurant Association, I want to point out,
Do you think that they should get rid of?
submitted,
Just simple, we already heard the testimony. I mean, do you think that the restaurant, do you think that Panera and all them, because you kind of seem like you like that idea, should get rid of the tip prompt altogether?
no, I did not say that at all.
Well, you said you go to one that doesn't have it. So I thought that you liked it.
What I'm saying is, if this becomes law, again, this is not requiring tipping. If this becomes law, a business that has been using the tip money for overhead or something else that just doesn't want to deal with this anymore and doesn't want to risk a complaint to the Department of Labor can do away with the tip screen entirely. That is an option.
Do you mean that? Because the whole tip thing is really important to the industry. I know for a variety of different reasons. I mean, you mentioned wage theft, but this is a tip from a customer, and I'm not even sure what wage theft is, but I guess, go ahead.
The tips, if someone is a tip worker, they have an hourly rate, but the tips makes up the difference to give them a full wage. And so if they don't get the tip, it's wage theft.
So, but at Dunkin' Donuts, they have to pay minimum wage at a minimum because they're not a full service restaurant.
Correct.
Okay. So that what you just said is not true in that case with respect to this bill. So I guess my other question is there's this argument, and this is interrelated, and I have to ask it, even though I'm sure we'll hear the bill about, getting rid of the tipped wage altogether in restaurants. And I just, I mean, do you support that?
Our union has been on record to support that. Absolutely, yes.
I see. So you really don't like tips?
It's not that I don't like tips.
Delegate Fisher, this bill does not make any judgment about tips. And I do want to point out, Mr. Chairman, that the Restaurant Association is not opposed to this bill and has only a letter of information saying it could be challenging to put this message on the same screen as the screen that asks you to put in a tip. That is the only comment by the Restaurant Association.
Mr. Chair, I find this bill very, very interesting. And I guess one of the questions that I had is since the pandemic, as the pandemic hit, I think there were a lot of people, myself and many, many people that thought, look, we have to help people survive. So we tip when there was nobody ever received tips. And so we started tipping to try to get people to survive. As we've come out of the pandemic, it seems that a lot of folks have recognized that that's an opportunity to get tips and to create some additional revenue. Was there any conversation with yourself and the advocates? Was there any conversation on the concept of what's happened in a lot of cases is we're actually tipping before we receive the service? In other words, when you go to a restaurant today or pre-pandemic, you get your meal, the meal's delivered, you get all your beverages, everything happens, and then you tip based on the service at the end of the meal. Did you have any conversations at all? I'm just curious about, in this particular case, did you have any conversations about tipping before you've actually received the service? Because that's a big difference.
I did not, but that is an interesting question. I did get an example of someone who said that she frequents a coffee shop in Baltimore that when you order and you don't even go up to a counter, you order from a mobile device that's either at the table or somewhere else, and you're asked to add a tip before you even get your product, before it's even handed to you, and her comment was, wow, like how do you decide if you want to tip when you haven't even received whatever it is you're ordering? But we did not get into that level of conversation that you're asking about.
Thank you.
All right, I do have a question, brief and Joel, sir. So I'm just looking for bill number. Mr. Epps, you were talking about the individuals that you represent, that you're here representing, correct?
Correct.
Now, to be clear, those aren't all wage workers, are they?
No, they're not.
Right. So just because they work at the front desk, or just because they serve you hamburgers, or just because they serve you, period, that does not make them tip workers, correct?
Some of them could. It's based on classification.
That's correct. What I'm saying is there is no classification, there's no guaranteed classification that just because they're serving you food that they are a tipped worker. Because you mentioned tipped wages and people making up the tip wage with tips, but I wanted to clarify that not everybody serving you food is a tipped worker. They're making minimum wage.
No, they're tip workers. Their classification is tip. They are tip workers.
I'll walk it back. So when I walk into a Panera,
okay,
and I order food, and then they turn that little thing around and ask me for a tip, that person is not a tipped worker.
And I don't represent Panera.
I don't know who you represent. I don't know the companies you represent. I was going by the demonstration as you just discussed the workers. So you do represent people that serve food.
Yes.
But not all those food service workers are tip wage workers. Correct? Some of them people earn $15 an hour.
Some, I'm trying to understand. There's a classification that they're tip. In restaurant, we have tip workers.
That's correct. But you also have non-tip workers.
Yes, we do.
That's right. And you represent both.
Yes, we do.
There was my question. So not everybody you represent is a tip worker.
Okay.
Thank you. So I say all that to say, to make it very clear that not everybody who we tip for food is earning $3.33 an hour. That some people are earning $15 an hour. Because my concern goes along with David Frazier-Dago is this tip exhaustion, where I'm worried that your workers, I don't want to tip them anymore because I'm tipping everybody else. And Delegate Lehman, we kind of spoke briefly about this, and I'll talk to you because pardon me, I understand your bill and I think there's a way to deal with it. I understand everybody's consternation, especially on the penalty side, but also, having something where you got to get to know, you should be able to know who you're tipping. But my problem also is I'm tipping now way more than ever before I ever receive a service.
Right.
It's exhausting. It's exhaustive. And it's not, and the options are hilariously, they don't start at 18%. It's 20, 25, and 30%. And I just want a salad. I order before I get my Grubhub. I have to tip the person. And I feel almost extorted because they're watching me tip. They're watching to see what I bit before my food is made. And I can be brave, but I used to work in fast food, so I don't want to be that brave. I was a teenager. Things were different back then. It's $3.15 an hour. God damn it. Anyway, my point is, I was very tempted with your bill, delegate, and I'm not going to do this without talking to you because it's a bill with your name, and normally it becomes our bill once you give it to us. But I am very interested in putting in something that you cannot request a tip until you've received a service. Because I don't want your workers, and believe me, if it hasn't happened, it will. The people that deserve the tips, the people who are working for tip wages, I don't want people to be so exhausted because they've been through other places where tips have been demanded that they're now like, you know what, I'm going to give this person the bare minimum. Instead of the 30% that many people tip people we know that wait on us and give us amazing service, we're going to give you, if you're lucky, the bare minimum. And I didn't know, Delegate Lehman, I'll put you on the spot now, but I was thinking about putting that in using your vehicle. This bill is a vehicle. And don't worry, we'll have a conversation, but I just want to know if that was something that you had immediate consternation with.
Mr. Chairman, I thank you for that, and I'm open to suggestions on this. This is becoming, I'm officially delivering this bill to you. It's becoming your bill, but I do want to say there has been a lot written and said about in the media over the last year or so about tip exhaustion.
Yeah.
So you're not the only one.
And so, but I also do understand your point. I think the worry is the fines. And but again, I see your point. We all kind of want to know who we're tipping. And while some people may not tip to a company, some people may. But you're right. I think some people would like to know. So we'll do some work on that bill, and I'll get back with you. And I appreciate everybody presenting today. I believe that's all the questions and abuse you guys can receive for one day. So thank you very much. I really appreciate you guys. And we're gonna call our next group of individuals. Coralie Grant. All right, that's it. Is there a Miss Grant here? Seeing that. Grant is gone. So what bill number we on? I believe we're on Delegate Fair's bill. House Bill 469.
Good afternoon, Mr. Chair.
You have a panel?
I do. Thank you. Perfect. I don't know where they were, but they appeared from the crowd. Thank you. Chair Wilson, Vice Chair Crosby, and esteemed members of the Economic Matters Committee. For the record, I'm Delegate Chris Fair, presenting House Bill 469. In August of 2023, the Maryland Supreme Court issued a critical ruling undoing decades of federal and state employment discrimination precedent and the intent of numerous legislative bills from this body. In the John Doe v. Catholic Relief Services ruling, the state Supreme Court ordered that discrimination based on sexual orientation or gender identity is legal in Maryland because, quote, the General Assembly's practice, as we understand it, has been to specifically identify categories it intends to protect in anti-discrimination statutes. This bill is one component of rectifying the Supreme Court's call to action. For years, sex discrimination protection has long included sexual orientation and gender identity. The Supreme Court's ruling has forced the legislature to reaffirm its commitment to protecting all Marylanders from employment discrimination. Specifically, this bill seeks to clarify the rights of employment discrimination for ministerial exceptions. Despite rulings by the U.S. Supreme Court and the then Maryland Court of Appeals, identifying the right of religious institutions to discriminate against people from serving as faith mentors, positions as seen as critical to the core mission of the institution, the court has not historically extended the right to discriminate to the secular operational entities like CRS until this ruling. HB 469 simply clarifies and reaffirms the long-standing posture of Maryland that religious institutions may discriminate in employment hiring, however, only in employment of those employees engaged in religious activities. Non-religious activities for corporations and 501c3 nonprofits like CRS, for positions like office administrators, secretaries, and janitors should not be exempted from our strong anti-discrimination policies by any employer in Maryland. I urge the committee to recognize this legislation's importance and provide a favorable report for House Bill 469. Let us take a significant step forward in ensuring that our employment discrimination laws reflect our values of fairness, equality, and respect for all citizens. Thank you for your time and consideration, Mr. Chair.
Good afternoon. My name is Camila Reynolds Dominguez. I'm from Free State Justice. The Maryland Fair Employment Practices Act protects Marylanders from a host of discriminatory workplace practices. It contains an exception for religious employers, which attempts to preserve those employers' right to select the ministers and teachers of their faith in accordance with their beliefs. Similar exceptions are usually construed under the First Amendment to only apply to ministers, teachers, and others directly responsible for teaching the faith, striking a balance between employers' protected religious rights and employees' rights to be free from discrimination in the workplace. The U.S. Supreme Court laid out a test to determine who is a minister for the purposes of these exceptions. It later clarified in a subsequent case that whether the employee's duties include important religious functions is the most significant piece of the analysis. However, this past August, the Maryland Supreme Court in Doe v. CRS expanded the scope of this exception to apply to any employee that directly furthers the core mission of the organization, whether that mission is secular or religious or both. The rationale was that the statutory language applies broadly to all the activities of the employer, not just the religious activities. This is broader than what is required by both the U.S. Constitution and case law on the subject, which clearly states that the function of the employer's job to pass along the faith is the determining factor. Personnel who are not at all responsible for teaching the faith are now subject to the exception, leaving them exposed to employment discrimination compared with similarly situated peers, even as they do not possess a ministerial position under federal case law. HB 469 simply brings the exception in line with the U.S. Constitution's requirements, not more and not less. Religious employers will still have the absolute right to choose their ministers, teachers, and other employees that carry out the religious activities of the entity. This bill resets Maryland's exception to be squarely in line with the First Amendment by adding the word religious before activities, protecting religious employers and their employees. The decision confirms this on page 29 of the opinion. We think that this is the appropriate balance, and for these reasons, we strongly urge you to issue a favorable report. Thank you.
Greetings to you in the name of the one who called the cosmos into being, who journeys with us towards justice. Amen. I'm Reverend Emily E. Ewing. My pronouns are they, them, theirs, and I serve as mission developer for the Delaware, Maryland Synod of the Evangelical Lutheran Church in America. But today I come to you as a pastor who served in two of the wildly different contexts burdened by John Doe v. CRS. As a chaplain during the height of a global pandemic in a hospital with thousands of staff, and as pastor of various congregations with barely one or two staff. I am the ministerial position in question today, and I promise you that my job and that of an ER nurse or the part-time church admin are not the same. I testify that neither the community nor the most marginalized Marylanders of faith are served justice while Doe v. CRS reigns supreme. Neither the part-time queer church admin who just needs to get the newsletter out, nor the pandemic nurse on her 9th hour in the ER trying to keep someone alive deserves to work under the threat of being fired. Before John Doe v. CRS, appropriate balance existed. Should I fail as a faith leader, it was, still is, and will be in my denomination's scope to do with me as they see fit. I took vows. I wear this collar as a reminder to whom I am accountable. Neither my parish admin nor my nurse colleagues made any such vow. Faith affirms this difference, even demanding these jobs be far more protected than mine. 1 Corinthians celebrates diversity of all jobs, commanding us to protect the most vulnerable. The eye cannot say to the hand, I don't need you. Those parts of the body deemed weaker we treat with special honor. You must ensure this honor by protecting queer, disabled, and other marginalized Maryland workers. This is your calling. Please give a favorable report.
I have a question.
Yes, sir.
So because I'm just trying to walk through this, and obviously as an attorney, I follow the laws, they move forward. We talk about the difference between secular operations and religious rights. So if someone, let's say, has a Catholic church are you positing that a math teacher they should not be able to say a homosexual cannot teach math in a Catholic church?
So I think the court's ruled on this in a couple of instances, and they've talked about this. Teachers are seen as kind of faith. That's why I say faith mentors.
And see, that's where because that's what I'm saying. It becomes a oddly vague definition, and we don't. Obviously, it's been made a much more difficult balance, but make sure we don't trample on individuals' rights, because the same would be asked. So if I have a small church and I have a receptionist and I don't want to hire a transsexual as my receptionist, you may argue that that's not a religious. However, others would say, who own any business, that your receptionist is the first person they meet when they come into your business. So trying to figure out how to thread that needle between their religious rights, because I don't disagree with what you're saying, but I guess the problem is defining, like you said, it's the hospital is a perfect example of why, it's ridiculous. But then you have other people that if it's like my daughter, when she was in choir, one of the girls got pregnant and they took her off the choir and she couldn't understand, because we love everybody. And she's like, no, when you sing, you represent the church. So you don't get to be pregnant representing the church. And I'm curious to your position as to what you consider does and does not represent the church. So would a receptionist represent the church?
So I would say that they do not, from a simple secular position of an administrative job, but I believe, Camilla, you had the exact word for it. And
yeah,
the ministerial position is kind of the federal guideline, I guess, for how we resolve these questions. And the Supreme Court in 2012 in the Hosanna Tabor Evangelical Lutheran Church, VEEOC, kind of outlined a series of factors that run through, this analysis as to what is a minister under the federal constitution. And in a subsequent case, Our Lady of Guadalupe School v. Morrissey Beru, the court emphasized that whether the employee's job duties include important religious functions performed on behalf of the religious organization, that's the most important factor here. And so there have been, I think the Supreme Court held that, teachers, for instance, specifically kind of talking about what you're asking about, are categorized as this ministerial sort of position. But someone, as the Reverend said, like a nurse or a secretary or janitor, it's a little different, and it kind of comes down to that important religious functions piece.
I will just build on that briefly and just say John Doe in this case was a program data analyst for
Correct.
Catholic Relief
I
Service.
totally understand that because this is going to come up on the floor, we're going to have a discussion about just who is allowed to represent the church or what the church would consider their representative. And it's not every employee, without a doubt, but some would say a doorman represents the apartment complex. And so I'm only asking because these are things that we have to thread the needle. I don't think most people here want anyone to be discriminated against, but we also don't want to trample on religious rights and freedoms and who they choose to have represent them, not who they choose to have do work for them. So I get you.
Yeah.
But I just want to make sure you understand that we have to run that math, and obviously we'll figure out, make sure our language is clear as we can.
I appreciate that.
But yeah, I get where you're coming from. I just wanted to go ahead.
And one thing to note in the decision, they explicitly say that adding the word religious before activities in the bill kind of brings it more in line with that federal constitutional protection. And I think that's kind of the goal of this bill, is to just bring Maryland law squarely in line with the federal constitution. Mm-hmm. And then let the federal courts kind of decide where that line is.
At some point, yes, I agree. That's going to drift back up if we, but I appreciate it. So I don't see any questions. I think we've covered, no, you have one.
I won't tell.
Look, I do go to what they say. There are two kind of people: sinners and sinners saved by grace. I'm trying to be in that second category. Give me a second. What was that? Who's the final? I'm sorry. I believe you have a virtual witness, right?
I didn't.
No, was that well? I curse for nothing. That's fine. Thank you very much. I believe that that ends this panel. Thank you guys very much,
Mr. Chair. I appreciate your work. Thank you so much.
Last bill, colleagues, Delegate Chi. I'm looking at this. What bill are we on, guys? No, it's not in order. Hold on. Brief indulgence.
I came in opposition of the bill. Terry Creed.
1 second, sir. It was still delegate chief. We're fine, sir. Did that, were you missed on the last bill, sir?
No, 469. I came in for an opposition.
Oh, I apologize. Hold on 1 second. Mr. Creed.
Yes.
I apologize, sir. I see your name here. Please come up. Sorry, guys, the bill's not over yet. One more. Go ahead, you can begin testimony when you're ready, sir.
I want to thank you for letting me come and testify today concerning HB 469. I'm Pastor Terry Michael Creed. I pastor Independent Baptist Church, Clinton, Maryland. Also, I represent 116 Baptist churches throughout the state of Maryland, Maryland Baptist for biblical values. I want to say that we're opposed to this bill. We feel like religious liberty, the window is being shrunk with this bill. We understand this, that our freedom, we believe that every activity done in the church really is a scriptural activity. I can find, honestly, I have folks that work on buses that preach in church on Sunday. And so what I'm saying is our staff, they have come to a place where they function in many ways, but they also minister, as the former people said, they minister the gospel and minister to folks that come into our church. We are concerned with this. This law is taking the position that our employees have the right to stand in opposition to God's truth and stay employed in our ministry. And this won't stand in our ministry. Every person that is an employee of our ministry signs documentation of where they stand when they come to work with our ministry. We love people. We love everybody. I've had transgender folks in our church. We love people, but we don't agree with lifestyles that go opposite of the Word of God. And so we take a stand, and we want to come to the place where we say this, will not have an ungodly lifestyle promoted in our biblical Bible-believing churches. Now, if people want to come attend the church, that's fine. But there's a lot of jobs out there that people can assume the job market's really good today.
I'm sorry, I guess I have a question or two, because we talked about lifestyles and you kind of heard me joke saying there are two kind of people in this world, sinners and sinners saved by grace.
Yes.
So when you talk about the people that you allow when you work in your church, would you allow somebody who is divorced to work in your church?
Yes.
What about somebody who had an alcoholic past?
Yes.
What about a drug user?
You know, I mean, in the past, if it was in the past,
What about somebody who's been convicted of a crime of violence?
I don't think that would be.
Because I guess at the end of the day,
that would be difficult.
Convicted, they're out.
Yeah, and we run background checks on every person that comes to work. If they work with children, we run background checks. If they work with teenagers throughout the school, I have a school ministry, 170 students, daycares.
Okay, and I guess I could go down the list of things that we accept in our church as sin every day, and I didn't know where the delineation was between somebody who cheats on their wife in the church, somebody who beats their kids, somebody who drinks.
They would be removed from our ministry. I mean, they would be removed if those things happened.
And you find out
we have procedures, within our ministry, and we want to have the right people there.
Mm-hmm.
At the same time,
your ministry, I got, sir. And that's where we're drifting to. I got you for your ministry, but I'm talking your bus drivers. If he's an adulterer,
a lot of the people that are involved in bus driving, our full ministry, as I made in that statement, as I told you in the statement, everybody that works in our ministry, they come together as a staff, they sign paperwork, and they agree to the doctrinal stands of the Word of God. Even down to the people that are working in nurseries and working in different places. And so
if they backslide, do they get fired?
Pardon me?
If they backslide, do they
We-
get fired?
I wouldn't say we fire them. The Bible says that you need to restore. If you're a spiritual person,
Correct.
you restore people, and that's what we do. We do everything we can do to restore people. As I said, I had a transgender person come to our church, and it was the very first time we had it. And I walked down off the pulpit and I said, "Can I help you?" She actually walked forward, and I said, "No, I can't do this." And I said, "You can do this."
No,
I said, "I love you, and I'll help you any way I can." And she said, "Yes."
And I appreciate that. I will say just lastly that it's kind of like, you know, a lot of churches do a lot of preaching, but they don't feed the people.
Right.
You can't, if you can't, a hungry person is not going to hear God's word. So I'm always confused when we want to isolate a certain group of people out of our church when that's the only way they're going to hear the word
Well,
of God.
that's what church is about.
Yes, sir. And
Now-
also having food to, you know, feed your belly.
Now,
is a
we're
part of it.
talking about employees versus
Correct.
folks attending church.
Correct. Like I said, and we're trying to find out, we're trying to draw that line with ministering versus somebody who just works on who sweeps your floors.
Right.
Or a janitor. And I just wanted to hear from you as a man of
And let me
God.
say, I've said it before, but the people that are sweeping the floors are also ministering to people.
Oh, no.
The person that's working on our buses, he runs our Spanish church. He had 85 Spanish Sunday.
But if he was just working on your buses, he might not be doing it. And I'll say this is according to my pastor, we're all ministers.
Right.
We all have a job, whether
And
you go to church.
that's how
whether
it
you
is
work
in our church.
Yes, sir. And I just wanted to get the delineation from you. It doesn't sound super clear, but I get it.
This seems like it is closing the window on religious
Well, I think
freedom.
the Supreme Court opened your protection is pretty wide open. And I think we're just want to make sure we walk that line between protecting and isolating individuals and religious rights. Because I agree with you. We do have to have religious rights. But we want to make sure in these non-consequential positions that they're not being excluded because of a lifestyle.
And like every religious organization, Muslims, Baptists, Catholics, we have a
Standard.
doctrine that
Yes,
we
sir.
stand on.
I agree. And I understand.
And that's why we take this stand.
Thank you.
Thank you, Mr. Chair. Mr. Creda, would you, do you mind answering my question?
Yes.
Thank you. Thank you for your testimony. So I understand in the state of Maryland, as it is in many other places, churches are exempt from, let's say, property tax, right? So in other words, all of us subsidize for your existence.
Right.
To some extent.
There are
Whether their
some
lifestyles
taxes.
you approve or not.
There are some
Right.
taxes that come through, even though they.
Yeah, you
don't
pay
call-
sales
don't call
tax,
it- you
you
don't
pay
call it a
income
tax, but-
tax and all of that, but you don't pay property tax and you exist in our community as a member of the community. And therefore, we have the rightful expectation of non-discrimination, especially as it relates to people applying for jobs that have nothing to do with the essential part of your faith, whether you believe in whatever. That's one. Two is, don't you have evolution of your lifestyle, quote unquote, definition over time now versus 100 and 200 years ago, you think?
The Bible hasn't changed.
The Bible has not changed. People interpreting the Bible has changed and you have
And
changed, right?
That's.
And your
no,
membership
no, I
has
haven't.
changed,
No.
right? Taxpayers have changed,
No.
right?
I preach the same thing that I preached when I started 40 years ago.
Okay, I think we can agree to disagree, but you get my point. Thank you. Isn't that so?
Isn't what so?
So, Pastor, one of the great pastors I listen to is Bodie Bach. And what he talks about is ceremonial laws versus the moral laws. And when I hear from some of my folks saying about, you know, this, that, and the other, these folks that, you know, oh, they don't shave their beard, they trim the edges of their beard. Those are ceremonial laws. And what you're trying to convey to the committee is that you're a herald of the gospel and the moral law, which has been unchanging. Is that correct?
Yes.
Okay. If you had a member driving a bus and or doing some part-time pastoring to ministering youth, whatever it is, and they had an addiction problem or they had some marital problems, so you would do what the church is called loving them through that, but they may step back from that role.
We have they're in the Bible, Matthew 18, verse 15 through 18, as church discipline. If people don't repent, then if they do, the Bible says that you need to accept them and you need to work on them, help them. And I can say over 40 years, I could bring a room full of people here that are ministering, that have blown it in life. that have blown it.
We see them on
I've
TV
had
every day.
folks, I have folks that are in our church, folks that are doing jobs that once were in a mission and they got their addiction straightened out and now they're doing right. Their family is in a house. They're not sleeping on mattresses on the floor anymore and they're serving the Lord. And that's what the church is about. I have no problem. I can't not love the people that were just sitting here, but I don't stand biblically with where they stand, the moral standing.
And so, but you have a process. So if something like that.
There's a
comes
total process in the church where we help people constantly. We have Bible study classes. People are being discipled according to the Word of God. And we don't teach what we believe. We teach what the Word of God teaches, and that's where we stand.
Thank you very much, Pastor.
Thank you, Mr. Chair, and thank you for being here today. Just to sort of wrap up what my last two colleagues brought up, our chair and Delegate Howard. So just to sort of delineate it between the difference in the corporate world and a church, it sounds to me like if you would draw the line between a process improvement plan for an employee to go on a PIP and there's been identified a problem. So it sounds like you have a process that's very fair and that you would work with them. You're not routinely firing people because they somehow make a mistake. Is that correct?
Biblically, there's a process, and we love people. We want to help them from where they are. We don't want them to reverse. We would rather them go forward. We love their children, their homes to be successful. We have people on staff that there's not a perfect person in this room,
right,
and there's not a perfect person on our staff. But they all have come to identify with a doctrine, a biblical doctrine they've signed. And if they mop a floor, they work in the kitchen. If they drive a bus, they're doing something scriptural, we believe.
Thank you. So God is a God of second chances. Isn't that so?
He is a God of a second chance. I've got so many stories right now that I could tell you, but it would shock you where people have come from.
Thank you very much.
Delegate Fisher.
Thank you. Just briefly, we heard some questions about nonprofit status and so forth. There are, I'm sure, near your church and so forth, I'm sure there are a lot of nonprofits that are not religious organizations, right? As well.
I guess there are. I'd have to think about it.
Yeah, I mean, it's interesting because many of us on our side of the aisle have opined that some nonprofits have taken on the status of religions themselves. And I choose not to participate in those.
Right.
No one has to come to your church. There are other places they can go. Is that right?
As I said, there's a lot of jobs out there.
Exactly. Thank you.
Well, Pastor, thank you for coming up and testifying and espouse.
Thank you for letting me come. Thank you.
Thank you very much, sir. I hope you have a good day. I do believe, and that now concludes this hearing. We are now on Delegate Cheese, House Bill 571.
Mr. Chair, may I bring my panel? With the Secretary and the Assistant Secretary for Family, please join me. Thank you. All right. I believe I'm second to last on today's list. Good afternoon, Mr. Chair and the wonderful colleagues of the Economic Matters Committee. For the record, I'm Delegate Lily Chi here to present HB 571. I think this is my first bill for this session in front of my own committee. HB 571 is to further modify the Family and Medical Leave Insurance Program, known as FAMILY, that we finally passed last year. It was a milestone piece of legislation that we should all be very proud of. Whether you personally voted for it or not, just know that your constituents would benefit from it, as well as many employers. residing in your district. As you recall, last year's bill settled a range of important issues related to contribution rates, small business exemptions when it comes to employer contributions, the split between employers and employees, qualifying events, leave length, and benefit amounts, etc. So this year's bill is about ensuring a smooth rollout of the family program for both the Department of Labor and for the employers that have to administer the program. As you heard earlier this session from the Department of Labor leadership, the whole family division, which was established after the bill took effect, has been working very hard engaging stakeholders, and they reached out to my office multiple times in the process as well, learning from other states' lessons and practices, hiring a new team, evaluating technologies they should deploy, and writing regulations. So now a year later, as a result, we are before you to request some necessary fixes and technical changes, which broadly fall into three different categories. One is the timeline shift. The second is administrative changes, and the third is clarifications and corrections. I will let the department get into more details, but I want to just highlight a few things to call your attention to them. One is the timeline shift. This bill would move the contribution start date by 9 months from currently October 1st of 2024 to July 1st of 2025, and move the benefits distribution date by 6 months from January 1st of 2026 to July 1st of 2026 to ensure a smooth rollout. And this would also make sure that key infrastructures such as technology, proper technologies are in place to process the data and administer the program. Another change is the definition of wages to align with the existing unemployment insurance programs wage definition so that it's easier for employers to calculate wages because they are already familiar with that definition. The bill would also enhance data privacy and protection about what kind of data that the department is allowed to share. And give the department the ability to assess a fee to cover the administrative overhead of evaluating private plans when employers want to be exempt from the state plan. And finally, the bill would give the department more flexibility to approve employer-sponsored self-insured family plans. So with that, I will turn to my expert panel to have them elaborate on the specifics, and I urge a favorable report. Thank you very much.
Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chair, and members of the committee. For the record, my name is Portia Wu. I'm the Secretary of Maryland Department of Labor, and I'm here to express the department's support for HB 571. I'm joined by Elliot Skur, our Assistant Secretary over the Family Division, and Regan Vaughn, who's our Policy Director. I want to thank Delegate Chi for her continued strong leadership, and I want to thank the committee for their working to bring paid family and medical leave to Maryland. The department is excited to build this program that will serve 180,000 employers and 2.8 million workers in our state. We're committed to establishing a lasting system that's responsive to the needs of both workers and employers and helps make our state more competitive by keeping people in the labor force and supporting them in times of need. As Delegate Chi mentioned, we have started the program and launched it. We did not have the staff and budget till towards the very end of last session. And that is the reason we are seeking some additional time to work on the program. State procurement processes are not speedy, although we are trying our best to accelerate them. And I'll leave it to the team to speak in more detail about that. I do want to emphasize that we understand this is still a very aggressive timeline, and intervening factors could impact our ability to meet these goals. However, as I've said to the committee before, I firmly believe that without an ambitious timeline, the work will languish, and it is our responsibility as a department to try to go as speedily and as effectively as possible to implement the will of the Assembly. We understand that to be our charge given by this body. So HB 571 provides the department with additional time and tools needed to implement family and medical leave insurance. We respectfully request a favorable report.
Thank you, Mr. Vice Chairman. My name is Elias Gurr, Assistant Secretary at Labor for Family Medical Leave Insurance. Over the summer and fall, the family team undertook an extensive stakeholder engagement process. We held 9 public meetings with over 1,000 attendees. We issued 12 documents for public comment and received those comments. The feedback we received during that process influenced our work so far in operationalizing the statute. We've reached a point where we've incorporated that feedback and reached consensus where we could with our stakeholders in our draft regulations, which we've published informally for feedback, again, with our stakeholders. But our stakeholder feedback and extensive research that we've conducted into best practices for paid leave programs in other states and for social insurance programs like this generally and in the state of Maryland has brought areas to our attention that cannot be addressed through regulation, but instead require changes to the statute. HB 571 reflects those identified changes, and that's why we're here today. I'd like to review a few of those changes we're requesting in the bill. We're requesting the authority to issue grants so that we can work with community partners to educate the public about family. We're requesting the ability to make the State Family Trust Fund sustainable by spreading the costs for family administration across participants in both the state fund and private plans. To do this, the bill allows the charging of reasonable administrative assessments on employers that choose to use a private plan instead of the state plan. This ensures the costs of these administrative activities are not borne solely by those choosing the state plan, as is the case under current law. Thank you. Oh, okay. We are requesting, I knew I timed this out well. We are requesting changes to the definition of wages. Okay, that's okay. We're requesting, as Delegate Chi mentioned, changes to the definition of wages, and we're requesting the ability to establish reasonable criteria for our division to use when evaluating employer application for self-insured private plans. These changes will ensure an administrable and a sustainable family system for the long term. And so I respectfully urge you to issue a favorable report on HB 571.
Mr. Vice Chair, my name is Regan Vaughn. For the record, I'm Director of Policy for Family, and I'm just here to help with questions. Thank you.
Delegate Weibel.
Thank you, Mr. Chairman. I see where you've made changes to allow someone to self-fund or use a third party, but on page 5, it says, beginning July 1, 2025, each employee of an employer, each employer with 15 or more employees, and each self-funded or self-employed individual participating in the program shall contribute to the fund. So the way I read that, even if you set up your own plan, if you have more than 15 employees, you still have to contribute to the fund. Shouldn't you also have an exception in there for someone who is either self-funding or choosing a third party?
The way we're going to administer the program is that we will not require contributions, mandatory premium contributions from employers.
But that's not what it says here.
You are correct.
So would you offer an amendment to change that language?
There is language I'm looking for you, Delegate, later in the statute. I don't know if it's reprinted in the bill, but there is language in the statute that talks about not paying the contribution if you're in a private plan. But we'll get that to you.
Okay, thank you.
It's a notwithstanding paragraph.
Yes, it says that the general rule and then applies an exception. If there's any ambiguity there, and it sounds like there might be, that should be clarified. It is our understanding and the way we're administering the program is that employers obtaining private coverage will not make contribution. But we'd be happy to work with you if there's uncertainty.
All right, Delegate Fisher.
I was just curious, do we know how many companies in Maryland have 15 or more employees? Or is it more than 15? It's 15 or more. Okay, just making sure.
Approximately 15% of businesses have fewer than 15.
Approximately 15% have fewer, but do we have which is helpful, but do we have a number, like as of today, how many businesses this would apply to who have 15 or more? Like an actual number?
I'll do the math in my head in just a second. But I will just say all businesses are required to comply and participate, but businesses with fewer than 15 just do not have to provide the employer part of the contribution.
Which is significant.
Which is significant.
Yeah.
It's essentially a 50% discount.
That's my question. And I ask because I think it would be helpful, I mean this sincerely, for the department to know how many companies reduce to just below 15. I mean, not that you would know how many did, but like, would we have fewer companies that were 15 or more once this is fully implemented? I mean, so often, like Republicans, say, well, we're gonna move or whatever. Oddly enough, though, when you go to King George County across the brand new Harry Nice Bridge, it's remarkable how many companies have moved over there. And they service Southern Maryland, and they only hire Virginia employees that don't have to comply with all this stuff. Now, you're just, I know you guys are from the department, so you're not policymakers, but I was just curious. I thought it would be a useful statistic to know if that has been reduced as a result of people kind of trying to comply and not contribute. So, thank you.
Remains to be seen.
Thank you, Chair. So the only question I have, and it would have been the same question last year, now that we're revising and throwing timelines out, had to do with this is insurance. So insurance requires some actuarial analysis. And are we solvent? Are we going to be solvent? Do we project it's going to be solvent? Are any of these questions being asked for the purpose of answering them as we continue to move forward?
Actuarial solvency questions?
Yes.
Yes, we are very sensitive to the solvency, the long-term sustainability of the family trust fund. We have received 2 actuarial reports so far. One we just received recently and has not been made public yet, but we're going to do that soon.
Okay.
They're public reports, and we are intending to acquire ongoing actuarial support to ensure the solvency of the fund. So that means we'll look at weighing costs and benefits, and also the long-term sustainability based on employers' choices for obtaining private coverage. But we are absolutely very sensitive and want to be responsible, actuarially responsible.
And Doug, if I might add, the contribution rate that we published in the fall was based on that initial actuarial analysis, and the statute requires us to do regular updates and reassessments. And part of our goal, even though we knew we would probably be asking for more time, is to give employers, far in advance a sense of the kind of cost they might be looking at, so they would have plenty of time to build that into their business plan.
Thank you.
Thank you, Mr. Chair. I was reading some of the testimony and it mentioned something in there that you'll have the ability to do grants.
Well, the grants are only there so the department can partner with nonprofits to get a word out, because this is across different sectors and including many small businesses whose owners may not be speaking English as a first language, et cetera, just to make sure there's adequate participation and awareness about that.
But if it'll be law, I mean, why do we need to publicize? If every business, save the exception, if every business has to do this, why do we need to give grants?
Delegate, the idea was we would give grants, perhaps even to local chambers of commerce, to get the word out, because we saw with paid sick and safe days, a lot of smaller businesses don't have an HR person. They don't have the time to figure out what does this mean for me. And so we thought it would make sense. I mean, the department can put stuff out, but honestly, people, they work with their local chambers, their local retailers association. Those are their trusted advisors. And so we thought it would make sense to support local organizations who have that voice, have people's ear. They're already going to those meetings to help them get the word out. It's really just meant to help people comply and provide
It's just a
information.
limited time we're going to be doing grants for a very specific person.
For a specific purpose of outreach. And I think with paid sick and safe days, actually, the assembly ended up funding some efforts in specific offices in the department. And from that learning, we realized there are a lot of questions. It's hard to reach a lot of employers because they're busy running their businesses. So it's
Is there
trying to
any
get that.
language to prevent it from being used for other things other than the advertising of getting people to
We can
participate?
specify.
I mean, it's meant.
We
for
can
outreach.
clarify the language
Yeah.
about what
Okay.
the grants are for and its limited use and all of that.
I worry because this is employer and employees' money that we're going to use to do something. Thank you.
Thank
Mr.
you.
Chair. Thank you.
Thank you, Mr. Chair. Just had a question. I'm actually looking at the fiscal note, and so it mentions that local governments that opt to provide a private plan may be subject to a fee. And it says as discussed below, I'm trying to quickly read, what kind of fee if a local employer, so our county employees, municipalities, what kind of fee are they going to have to pay?
It's a one-time fee to assess. It's a one-time fee to cover the administrative overhead of evaluating the viability of their own plan if they want to be opt out of the state plan. So let's say some public sector employers, whether it's public schools or local governments or municipalities, if they want to be exempt from that, they need to show they have a robust plan. But the department needs to have adequate staffing resource to evaluate whether that's the case by looking at multiple criteria. So the one-time fee they charge, which would be good for several years, is just to cover that administrative cost. So the people subscribing to the plan don't have to subscribe to that assessment.
Do you know what the cost of the fee is going to be?
Yeah.
So we're looking at what other states do when there's a request for a private coverage. Other states are always below $1,000. We have run some numbers preliminarily. We're looking in the low hundreds, $200 maybe. It depends on our overall staffing and the economies of scale that we're going to see based on the number of employers that make these requests. The rationale for the administrative assessment or the fee is that the administrative costs for family medical leave insurance to regulate a statewide paid leave program comes solely from the trust fund. And under current law, the trust fund is funded solely through employers choosing the state plan. And so that means that the costs that arise from an employer wishing to seek a private plan, the administrative costs to regulate that are borne by employers choosing the state plan. And so this is just a way to ensure that the administrative costs are borne by those who take action that give rise to the expense. But the actual dollar amount is supposed to be nominal just to cover the cost of administration. So $100 or $200.
Okay, and just as a follow-up, so I was a little bit confused because you said it was a one-time fee, but then you said, well, it'll be good for at least a couple of years, the assessment. So that's not really a one-time fee. So how many years are people going, if they chose to do that, how many times, how many years?
Until it's up for renewal.
And how long is that?
It could be at least 3 years, right? My understanding is.
Yeah, so the legislative change says that the department may impose reasonable fees. The actual fee structure, or maybe there's a fee schedule, will come out through regulation. And it's at that point that we would be able to have conversations with our stakeholders about what reasonable means. So currently we're envisioning in our proposed regulations that there would be some kind of renewal period, maybe a 3-year period, where employers would just need to recertify their self-insured or commercially insured product. And so it's possible that at that point that also gives rise to administrative expense on the part of the Department of Labor, that there would be some kind of renewal fee at that time. But it would be several years, so approximately 3 years, and it would be the same, approximately the same amount, $100 or $200.
Okay, thank you.
Thank you, Mr. Chairman. Whoever would like to take the question. So there was a part of the testimony talks about this bill would give MDDOL the authority to file written complaints and then adjudicate those complaints themselves. And so if you could speak to that and help us understand why you went that route versus, let's say, giving some outside third party the ability to do it.
So the intention there is to allow the Family Medical Leave Insurance Division to be able to perhaps rely on findings that are made by another part of state government. So for example, if there is determined to be non-compliance from an employer for unemployment insurance or another labor law or tax law administered by the Office of the Comptroller, that information should be reliable enough for the family division to take action and make sure that the employer is pursuing all of its obligations. So even if a complaint didn't arise from an employee, if a complaint against an employer arises from state government, that we would be able to investigate. It doesn't mean that we would immediately impose penalties. It just means that we'd be able to investigate to determine if there was a violation and to impose penalties already authorized.
But I mean, I think you said it, but you could immediately file or enforce penalties against the employer if you so choose, based on the way this is written.
I don't envision us ever imposing a penalty without due process, without making sure that a violation has actually been committed. But if it's determined that a violation has been committed, then we would impose penalty.
Thank you, Mr. Chair.
No further questions. I believe that concludes this panel. Thank you very much. We have one more favorable. Lisa Klingenmeyer. And then we have somebody on for virtual. Go ahead, ma'am.
Thank you, Mr. Chair and members of the committee. My name is Lisa Klingemeyer. I'm the Executive Director of Maryland Rise, and I'm the campaign manager of the Time to Care Coalition, which, as this committee knows, is a coalition of over 2,000 organizations and individuals that have been working since 2016 to realize a paid family medical leave program in Maryland. We're here today in support of HB 571, and we want to thank the department, thank the General Assembly, especially thank this committee for all your work to help us realize paid family medical leave in Maryland. We're really excited for the day when we can all celebrate the realization of this program and the wonderful life-changing effects it'll have. To that point, just want to note that we recognize there is a delay of the timeline in this legislation. If I had a magic wand, I would make this program accessible today. I haven't figured out that magical ability yet. So while we want the program to be in effect as soon as possible, we also want to make sure it's accessible and it's robust. And so to that end, we support the family division and their request to have a little bit of extra runway to get this plane off and flying. We look forward to our continued work in this space. We're here for the long haul to realize this program. We thank you for your time and kindly request a favorable report on HB 571.
We're gonna move on to our favorable with amendments. We have Bill George, Brianna January, Don Willems, Sarah Price. Well, I apologize. No, Ms. Price, I believe was unfavorable, so let's, thank you. You guys can begin.
Well, good afternoon, Mr. Chair, esteemed committee, Brianna January with the Maryland Association of Counties. In support of HB 571 with amendments, committee, the only issue that counties raise with this bill is those fees that were just discussed. The bill as written does not specify how often nor any amounts for the fees. So counties as good faith partners in implementing the family benefit do raise concerns over the department's ability to levy fees. We therefore request a favorable report with that amendment to take out those fees. Thank you.
Good afternoon, Chair Wilson, members of the committee, Bill George with the Maryland Municipal League. Here favorable with amendment on House Bill 571. The municipal concerns are echoes those of the counties and have to do with the fees imposed on those municipalities that were to take the private plan option. Throughout the discussion about this bill over the past several years, municipalities have hung our hat on the ability to have the private plan exemption, and the vague nature of the language that's in the bill is a little disconcerting as we work with finite budgets on a very strict budget timeline. And while the prior panel mentioned, what their plan is for this fee structure, with the swipe of a pen that could change in years going forward. Without that sort of stability, knowing what our budget options are as our members price out the plans to cover their members to comply with the law, it makes it very difficult. And as Brianna mentioned, we've been working in good faith with the department over the course of the interim in developing regulations and working on options for our members to be able to fulfill their responsibilities. And this came as a bit of a surprise, this fee option. So we're trying to work through it with them, and we ask for your favorable report with an amendment either excluding municipalities and public options, or excuse me, public entities from the fee, or striking it completely. Thank you.
Mr. Chairman, members of the committee, John Willems, representing the Maryland Association of Boards of Education, echo the comments from my colleagues from MACO and MML. This legislation, unintended consequence perhaps, but has generated a strong partnership, collaborative, Time to Care Act collaborative specifically between our organizations to generate cost savings and efficiencies in the private provision of a plan for our members commensurate with the state plan requirements. And we look forward to gaining those efficiencies. We understand that this bill is necessary to extend some implementations, and we've been at the table before in supporting a similar legislation. But we do have concerns about public fees from the state level imposed on public entities at the local government level, and would hope that the program could be administered without those fees. But do want to stress, the good faith, ongoing collaborative relationship we have, particularly, with Mr. Skur and Ms. Vaughn, and we certainly take to heart their comments in terms of making these fees de minimis or nominal in their nature. Thank you.
Delegate Chi.
Thank you, Mr. Chair, and thank you, panel, for your support with amendment. I read last night all of the testimonials very carefully, and had another last minute meeting with the Department of Labor to see how we can make it work for municipalities and local governments. We all are moving, toward the general goal to make it work. So my question to you is, if we add some amendment as you recommended to clarify, and you probably just heard from the secretary and the department their desire to clarify through regulation, right? And maybe there's intent behind the vagueness because they are still trying to evaluate how this could work. When I said one time, I meant until the next renewal. So they have to decide the period first of what is the reasonable renewal time, right? And then look at other states. And we're not the anomaly in terms of assessing a fee, because if you want the fund to be solvent, there are only two ways to do it. Either the rest of the taxpayers have to foot the bill, or the parties that want to be exempt and subscribe to private plan pays the fee, which to me is very nominal. If we're talking about between 200 to 1,000 or something, right? For government, so I hope we can make it work. We're all in the same spirit of making sure that people are covered. So thank you. Isn't that so?
Yes.
Okay, thanks. Okay.
Seeing no further questions. Move on now to the unfavorables. Thank you guys very much. Sarah Price and Andrew Griffith.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Andrew Griffin here on behalf of the Maryland Chamber of Commerce. Less unfavorable, more we have concerns we want to highlight for the committee. We've spoken to the bill sponsor, we've spoken with the department, and we're looking at ways to address the concerns moving forward. In my written testimony, you'll see the three primary issues we have highlighted. You've heard one, the grant making authority. It is less about the department having the ability to issue grants, more about setting some parameters around that. The amounts, the grants are coming from contributions. There should be some cap on the amount of grants given as to what the purpose are that the grants are given for. And I think we'll continue to work towards that. We are concerned with the removal of the ability of an employer to meet an exemption through a combination of insurance on a private market and a self-insured plan. From our viewpoint, private employers should be given every option to decide what plan works best for them, whether that be participate in the state plan, have a combination of plans. And so we would like to see that piece remain in the bill. And then finally, you've heard, or at least it was brought up about the complaint process. Our concern is not necessarily that the department itself can file complaints, but we would like there to be some recognition that in those cases where the department is potentially filing complaints, investigating complaints, and then rendering enforcement action, there needs to be some level of third-party involvement there. Continue to work with the department. It appears that's going to be addressed in regulation, but it's unnerving. It's a lot of kind of trust us and we'll address it later type situation. And so I just want to highlight those for the committee and look forward to addressing them as best we can in the statute. So appreciate your time today.
Good afternoon, Mr. Chair and honorable members of the committee. My name is Sarah Price, and I'm here on behalf of the Maryland Retailers Alliance. Want to make it clear, we understand this is not a second bite at the apple to say we oppose the whole program. Our perspective basically echoes the chamber's. This is largely Me Too testimony, but I do have additional thoughts on the sort of renewal assessment for the businesses that maybe want to opt out. I would need to go back and discuss options with our legislative committee. I can't recommend amendments that I just thought of 5 minutes ago, so we will follow up with the sponsor on that. But just generally standing with the chamber on this one. Thank you.
Thank you, Chair. So the question previously, the previous panel had to do with these fees. Now, I've not read what this bill is, but do you have an opinion on the fees? Does it not apply to private sector? What's the?
My understanding is the fees would apply to anyone who is applying for an exemption from the state plan. So it would apply to private employers. Frankly, we don't like the fact that there is a fee. They're not knowing what the fee structure is concerning, as you heard from the previous panel. I also recognize the fact that the department needs some, I think we recognize there's some level of administrative cost to the program. I just think that there needs to be a discussion as to what those costs are and what the fees are. So, kind of walking the fine line on that.
So my follow-up question to that is, and I know the bill sponsor said that we need to make sure we're solvent, and I brought up to the department, actuarial analysis, it's insurance, so it has to be solvent by definition, or else it's not insurance, it's something else, but it's not insurance. I think most businesses are going to try to figure out how to do this at the lowest cost available. I think a lot of businesses are going to effort to figure out how to deliver some requirement, some mandate that the government's putting forward. And it may be in all the above. And I'm not even talking about what your testimony is. I'm saying that when this day comes, I think a lot of businesses are just going to say, I'm going to self-fund, I'll show a bond, whatever the proof the department's going to need, they'll do it. And when we start talking about actuarial analysis, when we start talking about a fee structure that we don't know today as a committee what that even looks like, aren't you as the business community a little concerned about where this is headed, and that we're now a year later and these things don't seem to be vetted? I'll be blunt with you. I'm a little concerned.
I would agree with you. That's a big question. I will simply just say that, we've discussed this policy for many, many years. I think the concern you're raising is one we've raised for many, many years. The train's left the station. Here we are. We're trying to make this work as best as we can for the employers that have to administer the program and have to deal with it.
We do appreciate all the effort that the department has put into trying to make this as smooth a transition as possible.
Yeah. I mean, it's the businesses that are going to have to make it a smooth transition for the workers that take the benefit, right? I mean, that's the real thing. We're talking about solvency, and I understand why the department's worried about solvency. I'm talking, and I mean, maybe I'll just stop here and just make a statement and leave it at that, because I respect the idea that you're working to make this workable, right? You want this to be a practical application, but I'm just saying, as somebody that's got employees, when somebody says that there's a 15 employee limit, I mean, I'm higher than that in my business, so it's not applying to me, but businesses probably are going to look at it like that. I mean, I'll say to you this, that the minute that this becomes a real cost, that these things that you're talking about in your testimony about trying to find self-insurance or a combination of commercial insurance, that's exactly where most astute, business people that are just trying to deliver at the lowest cost, and maybe that's not using the state plan. So I'm worried. I'll leave it there.
Thank you.
Thank you, Mr. Chairman. Just really simple question. With the various programs, UI and family and whatever else is out there, Social Security. Now that we have more information about this family program, do we know what the actual stacking percentage would be now of an employer?
We don't. I think you're gonna we'll see probably in the future, an ask for a task force to review all of the leave that we have on the books and how it all stacks on top of one another, because it is quite impressive.
Yeah, it'd be interesting to know the actual costs on a per employee. I mean, I know it varies in different ways, but that looking at the grant aspect of this bill and maybe having you guys be the ones, or NFIB or whomever, retailers educating people about these various programs, seems like the stacking should be part of that education. Because
that's certainly a talking point for us as we interact with the business community. Yeah,
It does come up.
All right, I think that seeing no further questions, I think that concludes this panel. And I think that concludes this bill hearing. So next, we'll go to the final bill of the day. House Bill 205, Delegate Charkoudian, Unemployment Insurance Modernization Act. You can bring up your, I don't know how many panels you have, but bring them all up.
Okay, great. Come on up.
Great. Okay. Having an assigned seat today.
That's your assigned seat. That's right. All right. Mr. Chair, colleagues, for the record, Delegate Lori Charkoudian here, asking for a favorable report on House Bill 205. I know we have had a long day or long for us. I always feel kind of bad complaining when the folks are in judiciary. Would be happy to have days as long as ours. But I do want to actually start with, because we're going to talk about sort of a comprehensive set of changes that are needed for the unemployment insurance system. I want to start by doing some level setting about why I think unemployment insurance is so important and what it does for our economy. So what unemployment insurance does is it makes our labor market work, and it makes our communities able to survive recessions and tough economic periods. And that means our communities in terms of individuals in our communities. It also means small businesses and our local economies. And so just to expand out a little bit more on that, in terms of our labor market, we want, when someone loses a job, we want them to search for and get another job as quickly as possible, but we also want them to get the right job, because if people are desperate and taking any job that comes their way, they're going to leave that job very quickly and take on the next job that is better and more suited for them. And that is not good for businesses, because there's a cost to the hiring and the training, and then having that person leave because it wasn't the right match is problematic. And so we want to make sure that while we have incentives that are structured to make sure that people are looking for work when they're out of work, we also don't want to have the incentives structured such that people feel desperate and are just taking anything, because that is not good for the employees. It's also not good for employers and businesses. The second thing, and the broader economic literature shows this, is that having sufficient unemployment insurance helps people survive, of course, a spell of unemployment. Having sufficient unemployment insurance means that people don't lose their homes, don't lose their cars, don't end up in poverty as a result of losing their jobs. Also, it means that we can keep money flowing in our economies. And I think during COVID, we saw this very clearly, and all the analysis suggests that if we hadn't had a lot of the incentives flowing into our economy, but in particular, the extended unemployment insurance, what we would have seen was a much really significant recession and a much harsher impact on a lot of our businesses, and we would have lost more small businesses. So I want to say that because I think it's really important that we're kind of coming into this conversation with an understanding of all of the different sort of individual level, business level, community level, economy level benefits that unemployment insurance has. And because of that, we have an obligation and a responsibility as a General Assembly to make sure that our unemployment insurance system is solvent, is functional, is healthy, and that if it were to run into any challenges, that we could borrow money from the federal government at 0 interest rates. And where we're about to be in the next few years is a very insolvent place. And we're about to hit points in our unemployment insurance trust fund, which would mean that we wouldn't be able to, should we need to borrow money from the federal government, we would not be able to borrow it at a 0% interest, which, we count on being able to do when we hit recessions. And that is because the trust fund has something called the average high cost multiplier. And the average high cost multiple is when it goes below 1.0, it's a signal that our trust fund is not in good shape. And when it continues to go, when it continues to drop beyond that and heads towards 0, we could actually be risking an insolvent trust fund. What you have in your bill, with my testimony, you have a number of reports, but one of them is this fact sheet, and on it you can see this analysis that was done a couple of years ago, and you can see the various scenarios that show what happens with the trust fund, and you see in a couple of years that it falls below 1.0, and that's really where we start to run into trouble, and where we also run into trouble in terms of our ability to borrow from the federal government. So the first thing that this bill does is it tries to address the health of our trust fund. The health of our trust fund is dependent on the amount of wages that we apply the unemployment insurance tax on. And the amount of wages that we apply that tax on was set at $8,500 in 1992 and has not been increased since then. So in that time, if we adjust that for inflation, that amount would be $18,880 today. And if we were taxing even close to $18,880 today, we would not be anywhere close to the challenges that we see in this trust fund. I do want to back up and say one other thing. Those of you who were here a couple of years ago, you might recall we took $1 billion from the federal the package that came, the COVID package. We took $1 billion and we put it into our trust fund to prop up our trust fund. And so one of the reasons it's as healthy as it is, even though it's not healthy, one of the reasons it's as healthy as it is because we took that $1 billion a few years ago and put it in there. If we hadn't taken that $1 billion, we probably would be insolvent right now. So in order to not find ourselves in a difficult position in a few years and in a really difficult position a few years after that, it is incumbent on us and the responsible thing to do to update our taxable wage base from the $8,500 fixed amount to an updated amount and then an indexed amount so that we don't have to come back and have this conversation every few years. The bill sets that amount at 25% of the average annual wage, which is $17,682, which is actually below what it would have been had we indexed the $8,500. But what you can see in the chart that's in your files is that even if we indexed it at 20%, we still could move forward with a healthy trust fund. And so this is one of the areas where it's clear to me that the responsible thing to do is to reset this taxable wage base, set it at an amount that is that will make us solvent and then index it going forward. But there is some conversation, and I have been in some conversation with the chair and the vice chair and others, the Department of Labor, about what the exact right amount is for that. So I remain open to that. That's the first thing that we absolutely have to do to have a solvent trust fund. The second thing that this bill attempts to do is to make sure that our weekly benefit amounts allow people to not drop into poverty when they need unemployment insurance while they're looking for the next job. And so we adjust the maximum and minimum weekly benefit amounts. Again, these two amounts were last updated in 2010 and have not been updated since. What many states do is rather than having to come back together, to update the amount every 10 years, 50 or 15 years now, is they index the minimum and maximum amount to the average weekly wage. And again, what you can see in your in the fact sheet, if you have it with you, is all the other states that index the amounts and the amounts that they index them to. And so you can see the states that index them to 70% of the average weekly wage, as low as 43%, and everything in between. The average is 0.56%. This bill again sets the maximum weekly benefit amount at 2/3 the average weekly wage, and it sets the minimum weekly benefit amount to 15% of the average weekly wage. Right now, the maximum benefit amount is $430, which is significantly below minimum wage. So you might have been making, $1,400 a week, and you're now making below minimum wage. You're making $430 a week, and so all of your bills, your mortgage, everything else is still there, needs to be paid for, and you're making less than what we have established as the bare minimum in the state. So those are two significant things. I want to highlight two other things that we're attempting to do with this bill. And one is addressing the income disregard. And so right now our income disregard is when people have two jobs and they lose one of them, the amount they're making on that second job is sort of held against them in the unemployment insurance that they would receive from the job that they lost. And this is problematic because, of course, people who are working two jobs generally need the income from both jobs. And so if having that second job keeps you from getting the replacement income from that first job that you lost, you're definitely not able to, make ends meet. But in fact, it ends up creating a disincentive to continue working the part-time job or that second job that you might have. And so this adjusts the income disregard. And the third thing that this bill attempts to do is to sort of cushion the recessionary impact on businesses. And so one of the things that happens for businesses because of the way that the economic cycles function is that when we go into a more challenging economic period, unemployment rises, we need to replenish the trust fund. Often we end up with the rates at the most difficult period of time for businesses in the recession, the rates that they're paying end up going up the quickest. And so by slowing down how we move from table to table, this bill cushions those effects. And so businesses sort of have until we get into better economic times to be paying back into that trust fund, those higher amounts. I know this is very technical. I know it's almost 4 o'clock. So I am happy to sort of walk through the details of this and of course, answer any questions. But what I want to just say by way of context is all of the pieces of this bill right now, what's in front of you, came out of the study that we commissioned in 2021. The Department of Labor hired the Upjohn Institute to do economic analysis organization out of, I think, University of Michigan, to do a series of analyses about where we were, how that fit with other states, what it is we need to do to ensure solvency. And they laid out a few options, but the pieces of this bill come out of that analysis. And one of the things that Upjohn did for us is they took the bill and they sort of modeled, okay, if you do the bill, if you do sort of A, B, C, and D in the bill, then here's what the next 10 years look like. If you change C and D to X and Y, then here's what the next 10 years look like. And so it gives us a good sense of, again, this idea that we can make responsible decisions today that will ensure the health of this trust fund over the next 5, 10, 15, 20 years. And I'll stop there and look forward to questions.
There you go.
All right. Chairman Wilson, Vice Chair Crosby, and members of the committee, thank you for the opportunity to testify in support of House Bill 205. My name is Ali Sarine, and I'm a member of the policy team at the Cash Campaign of Maryland.
Cash stands for creating assets, savings, and hope, and we promote economic advancement for low to moderate income individuals and families in Baltimore and across Maryland. More than half of our clients earn less than $20,000 per year, with many earning less than $10,000. Cash provides a variety of services to Marylanders, including free tax preparation and benefits screening. Last year, our benefits team worked with over 600 households across the state to receive benefits, including unemployment insurance. Unemployment insurance is a basic and essential safety net for workers who are temporarily unemployed through no fault of their own. It can be difficult for people to reconnect to the workforce once disconnected, and it is a critical safety net for unemployed people because it helps to combat some of the barriers to finding employment, like affording food, housing, and transportation. Having a robust safety net protects workers from excessive debt or falling behind in paying their debts. This ensures that once they find employment, they will not be as financially strained. According to Prosperity Now's most recent scorecard for Maryland, 20.2% of Maryland households experienced income volatility, and 26.7% had difficulty paying for usual household expenses. This shows that at least 1/5 of Marylanders struggle to pay for basic expenses and should not have to experience greater periods of financial stress due to temporary unemployment. House Bill 205 would ensure that Marylanders are better supported during periods of unemployment so that they're able to provide for themselves, their families, and are set up for success when they re-enter the workforce. For these reasons, we urge a favorable report on House Bill 205. Thank you for your time.
Just gonna
Thank you.
alternate. Go.
Okay. Good afternoon, Mr. Chair and committee members. Thank you very much. I'm Donna Edwards. I'm president of the Maryland State and DC AFL-CIO. I want to thank the sponsor for a very well thought out and presented bill. She spent a lot of time bringing everybody together through the interim. I also am very aware that we are probably standing between you and champagne and candy and romance. And so we will I will not go over what we've written. It was said, my vanity is preempted by the importance of this bill. So 30 years ago, I worked with the Joint Commission on Unemployment through the Senate and the House. And we agreed to work with business and eventually move towards the maximum benefit reaching 2/3 of income. We're now 30 years later and only at 44%. So I see this from both ways. The state federation that I run is a small business. I have been pinged at the furthest, most costly amount. But I would like to just add, Maryland is the highest medium household income of all states. We remain at that. And yet we are 37th in the maximum payout for unemployment insurance. There is something very wrong, very unbalanced with that. Secondly is throughout the almost century of unemployment insurance, everyone talks about allowing unemployment insurance should help workers who are temporarily unemployed to be able to maintain their consumption levels. That helps not just the workers, it helps our local communities, it helps our businesses, it helps our state. The question isn't, can businesses afford unemployment insurance? The question is, can we afford unemployment? And we need to face that question while we can, while it's not an emergency. Please make a favorable report on House Bill 205.
Thank you, Vice Chair Crosby and members of the committee. My name is Christopher Meyer. I'm a research analyst at the Maryland Center on Economic Policy in support of House Bill 205. Maryland's current unemployment insurance system is deeply inadequate. It does a deeply inadequate job of protecting workers from the income shock of job loss, does a deeply inadequate job of protecting our economy from the rippling out spending damage of job loss. And it does a deeply inadequate job of supporting itself and making sure that it is solvent. In the third quarter of 2023, weekly unemployment benefits in Maryland averaged only $378. That's not nearly enough to maintain just a basic living standard. And in fact, in October of last year, 25% of adults in Maryland who used unemployment benefits to make ends meet were struggling to put food on the table. That's more than double the number of other adults. An adequate unemployment insurance system is a matter of racial justice. In the third quarter of 2023, while 1.2% of white Maryland workers were unemployed, that is actively looking for a job but unable to find one, 1.4% of Asian American workers in Maryland were unemployed, 2.1% of Latinx workers, and 2.4% of Black workers were unemployed. Regarding the wage base, not only is a sufficient wage base necessary to make sure that our unemployment system is solvent, but a higher taxable wage base actually lowers the rate that's necessary to maintain solvency and reduces the volatility in that rate that's necessary. Last year, the U.S. Department of Labor reported that our average high cost multiple was 0.92. It hasn't been 1.0 since 1996. So this bill would make our unemployment system more effective, more equitable, and more solvent. And I'm asking for a favorable report. Thank you.
Chairman Crosby, committee members, my name is Rico Albuquerque. I'm here on behalf of IBW Local 24, that's the electrical workers in Baltimore. And I want to urge you to give HB 205 a favorable report. I just want to speak briefly from the perspective of someone who has lived on unemployment benefits. The last time I was unemployed and collecting benefits, I had a brand new baby girl. And thankfully, the $430 was enough to pay my mortgage, to pay my car note, to put food on the table, and to provide a little bit for that new family. The problem is that was nearly a decade ago, and that same $430 today does not have the same purchasing power with housing costs, grocery bills, all that stuff being much more expensive now than it was nearly a decade ago. And so for those reasons, I'm urging you to support HB 205 and looking forward to taking any questions. Thank you.
Thank you, Mr. Chairman. Just one question. With the advent of a lot of these online job searches, my personal experience has been that people will click a button, send off a resume, and say they're actively searching for a job, when in fact they never show up for the interviews. Does this bill have any provisions in it where the employer can report the no-shows and the department can investigate that and potentially limit their benefit?
Yeah, so I want to sort of answer that in two ways. One is I've had a lot of conversations with employers in preparation for this and trying to figure out what would be some improvements that they would suggest. And we talked a lot about that issue. I spoke to the Department of Labor a good bit about it. And you might ask them, because it sounded like maybe there was a possibility of sort of like auditing some portion of the job searches. So if you said I applied to, Weibel's restaurant, then a phone call could be made to check on that. I don't think they have the manpower to be auditing every single kind of indication of the job search. But it's
I'm asking more for a way for an employer to just go to the department's website and say, William Weibel had an appointment today for an interview for whatever and never showed up. And that way you wouldn't have to audit them. It's the information provided to the department.
I think the challenge with that is that I could be looking for work from any number of places, and I could have applied and you could have offered me. I mean, people are rude, right? So you offered me an interview and I didn't even bother to tell you, but the reason I didn't tell you is because I got this job over here. Okay, so that's rude, but it's not illegal. And so I think the issue is you could report all day long that people didn't show up for the interview, but that doesn't necessarily mean they weren't following through on their job search. So this is an issue that I take seriously, and I have had a lot of conversation. I would encourage you to also talk to the Department of Labor, just because as I was trying to explore what would be the angle of, I think everyone wants the job search to be real. I think the vast majority of job searches are real. I think, like with anything, there's a handful of people who might not be real about their job searches. But I think everyone is in agreement that we want that to be a real search, but I think that there's I think that the suggestions that have been made to date, like the one you just made, sort of don't fit with the way that the Department of Labor receives and tracks information. So they can speak to it more. I will say if we could find some solution to that issue, I am open to incorporating it.
So do you know how the department today verifies whether someone is actively searching for a job?
I have some ideas of it, but since they're going to be up here in a minute, you guys are going to speak in a second, right? I just think that they could do a better job than my recollection of what they told me.
All right, thank you.
Thank you, Vice Chair. So Donna, I'll agree with you. The Delegate Charkoudian is one of the most thorough representatives we have here in the committee, and we appreciate some of these big bills because, frankly, the testimony you gave, there was a lot of subject matter, right? But can I just, Delegate, bring this to a simple, just generic question about what unemployment insurance is? I believe it is the ability to give an employee the bridge between a job A and job B as quickly as possible. Would you agree with that?
Sort of, but the reason I started with what I think it does, I think that's one thing that it does, but it's not just about employees. I also think it makes the labor market matching more efficient. I think that's a really important function. And I think that it makes communities survive recessions. I think, so I do think it's what you just said, but I think that's one of three key things that it does.
So the reason why I ask is because unemployment insurance is, and can only ever be, so much given the constraints with the UI Trust Fund and how it gets funded. And I think we have to be careful to not make unemployment insurance more than what it ever can be for us, or else it becomes something completely different from a cost structure, from a how we fund it structure. And I would just encourage you to consider that. You don't need to answer further, but just consider that this should be a program that has limitations, else it no longer becomes unemployment insurance. Now I guess my second question is, you had talked about this $1 billion that was infused in the UI Trust Fund. Now, you and I were here. It was all about COVID. I mean, it was all about making sure that we still had a state and that citizens were not going to be completely left out while, you know, the federal government and the state government shut everything down, right? So, I mean, that wasn't about you and I looking at it in the rearview mirror and saying, without that $1 billion, we'd be insolvent today. That $1 billion was the means by which we got through some of the worst 2 or 3 year periods in our state's economic history. Would you agree with that?
Yes, but with a caveat, because
Sure. You're thorough, and I appreciate.
And I'll tell you
I've
why.
talked about this offline a little bit, but
I'm happy to do that as well. But here's why. Because when we talk about the amount of unemployment insurance that was paid out during COVID, and it was a lot, and it's how a lot of people survived, or it's part of how a lot of people survived. But the vast majority of that was federally subsidized directly. It was not coming out of our trust fund, right? So there's a good bit that was coming out of our trust fund, but the extra $600, the extended benefits, like all of that really cost even more, that all was directly federally subsidized. So it's not like we were asking our trust fund to take on all of that, and thus it needed the $1 billion. Like, the trust fund was strained for sure, but it wasn't strained with everything that we think about having been what happened during COVID for unemployment insurance. So what I'm saying is, there's some of that $1 billion that covered just what happened during COVID, but some of that $1 billion really kind of is masking right now the kind of trouble we would be in for not adjusting the taxable wage base a couple of years ago. Some of that is being masked by that, and some of that is just sort of covering what happened during COVID.
So my last question, which is taking my first one and then the second one, and then making this final question, which is, because I believe that our state and our country has gone through this rubber band. It's sort of like you've stretched to get through COVID, and over the past couple of years, inflation has cropped up because of supply chain difficulties. And that I believe, while we're not snapping, I think it has adjusted the behavior of people as it relates to work. I'm not making I'm not making a judgment, but what I'm saying is that when you have insurance programs that take what people have gone through for the past 3 years, that it has broadly expanded. You're right. And some of this, we may not be able to go back to what it.
No,
was
no, it has
originally.
gone back. It has gone back. It's not still expanded. It's back. It's 26 weeks.
Else we wouldn't be looking at your bill, which is seeking to make the expansions.
No, no, no. It doesn't expand beyond 26 weeks. It updates the benefits.
You're raising the benefits.
That's correct, yeah.
Okay, so this is expanding. I'm not talking about timelines. Let me just finish my question.
Fair enough. Sorry.
I was trying to
Go
get to
ahead.
a place, okay?
Go ahead.
So if you take what our country went through and our state went through and how we had to finance UI and how citizens viewed unemployment insurance, and that we're now a couple, 3 years later, I worry that we're sitting here today trying to make unemployment insurance something that it can't be. And I was headed a different place, but you kind of stopped me. But I want to just encourage in this last question for you to consider that what we're doing, I'm not hearing from the department, so I'm going to want to hear from the department, but what's realistic and what gets people back to work? Because I still think we have people that are not dynamically looking for and then taking work. And again, just like the last bill, when we talk about solvency of the family program, if you're worried about solvency, you solve that by having people off of unemployment insurance and in the private or public sector making wages. That's ultimately, we have to agree on that. If you disagree on that, then we've lost the concept of unemployment insurance.
I do agree on that. I do agree that people being employed is the best outcome. And I believe that unemployment insurance supports that, as I said. But I think it's really important to highlight the fact that right now we are at record low unemployment. There's a record low number of people collecting unemployment insurance. The challenges that we're seeing right now with labor force participation are much more complex and actually have nothing to do with unemployment insurance. So you're right that the labor market has changed significantly. I'm not going to get into sort of my theory about all the reasons for that, but the people who are not participating in the labor market, for the most part, are not on unemployment insurance because this is, we're at the lowest point in, I don't know, they'll tell us in a minute, I'm sure someone from labor has it, like a very long time in terms of both unemployment, that is people seeking work, and people collecting unemployment insurance. So I think that, I don't think that the changes that have happened in the labor market are related to unemployment insurance, but I think this is a really ideal time to fix this rather than waiting until we hit a crisis point. When we do have huge numbers again, when we are in another recession, I think the responsible thing to do is to fix it when we do have very low unemployment, so that it allows us to phase in the changes, so there's not a shock, to the system, those kinds of things.
Thank you.
Thank you.
So the sponsor of the bill, so everybody knows, has training in economics, and so therefore her knowledge of theories related to employment and how do we get the economy going are like second nature. But for us mere mortals, I think I need a little bit of help. So what I would like, if you could provide, and because I'm trying to reconcile some of the comments I'm reading from the info letter that the Department of Labor provided and some of the unfavorables by the counties and the chambers. Is it any way that you can outline what the Upton Institute's recommendations were, the ones you're implementing, and if you modify them in any way, so that we can know, are they one for one or are we looking at some adjustment? Because I can't reconcile, is the Department of Labor happy with the department allowance, or are they just making a statement that it increased from $8 to $25? Are they happy or not with the income disregard that went from 50 to 250 and indexing it by inflation? I can't derive whether the model for the average high cost, the multiple, I read economics too sometimes, so I get a little bit of this hype, but the tax wage base, I can't derive. Are those one for one, the recommendations? Did we make some modifications? And I don't expect you to answer all of that right now, but we would like to know how that fits, if that makes sense.
Yeah, let me give it a shot with my version of a summary.
Also like.
So-
stay.
Yeah, so if you have the fact sheet, take a look at it because I think these are the most helpful visuals. Here's what I would say, the reports from Upjohn are about like 250 pages worth of reports. So, and do I need to say that I did read them all? But I think that, so it's hard for me to say like, here's everything he suggested we could do and here's what we took. But here's what I would say are like my big takeaways from him. And I've gone back to him a bunch of times and said, like, is there something else? Is there another way to address the trust fund? And he has said there is not another way to address the trust fund other than raising the taxable wage base. You absolutely have to do that. That has been recommended for years and years and years. So that is one for one. He said you have to do that. Now he models a couple ways to do it. He models 20%, he models 25%, he models 15%. One of his suggestions is get rid of table A. That's the lowest tax rates. He says, get rid of that, set it at 20%, you'll be fine. I didn't get rid of table A. I set it at 25%. So like within he kind of gave us a menu. So he said, like, you got to fix that. No question, no other way about it. You got to fix it. But then he gave us a menu of like, what could you set it at? And could you get rid of table A or not? So I would say like, and with these other areas similarly, he's like, yeah, your maximum and minimum, most states, the best practice is to index them. He said you could index them to 2/3, you could index them to 50%. You could do it this way. So I picked a number, but he definitely said like most states index them, right?
No, I'm not disagreeing. You're not picking. I'm not. I'm questioning. That been all, labor's on board with that and we all agree with that. And could we answer some of the chambers and counties issues? Is it just a tweak or what? So that's what I'm trying to get to. Is that making sense what I'm trying to get to?
It is, but I think the reason I'm answering it this way is I feel like my takeaway from Upjohn was you got to do something about the taxable wage base. And then we've got some choices and you got to do something about this and we got some choices.
And my question about your choices, getting the agreement on the choices.
Yeah. And
Okay.
so I met with, they will tell you.
We don't want to be all day, Dr. Charkoudian.
What is it that you, maybe I'm not understanding the question then.
I want you to come back with all what you're telling me in sort of a written kind of thing, and we can go through and I can say, oh, this is why they're concerned. So we can try to reconcile these unfavorables, if that makes sense.
Okay, let's do this. Let's you and I get together.
Yeah, I think this could
And go
probably
through that.
happen offline.
Okay.
You just bring her the data, probably the same report we've already gone through.
Yeah.
All right. Okay, seeing no further questions for this panel.
Thank you.
There's the virtual witness is not in the waiting room. We have one more favorable, Christopher Meyer. Oh, you went. I apologize. How about Samuel Epps? I don't know where Sam's at. All right. We will now go to the unfavorable. I'm going to call them all up at once. Mike O'Halloran, Bill George, Brianna January, Sarah Price, and Andrew Griffin.
Good afternoon, Mr. Chair, members of the committee. For the record, Andrew Griffin here on behalf of the Maryland Chamber of Commerce, in very respectful opposition to the bill. I'm going to just change my testimony and I'm going to kind of pick up where the bill sponsor left off. I think the primary concern from the business community when they look at this bill is they see doubling their UI tax because you're doubling the taxable wage base. And so I don't think anyone rejects the idea that the trust fund needs to be solved. I think from the business community standpoint is that have we exhausted, is there a good grasp of all of the options and the combinations, potential, elimination of table A, raise in taxable wage base, that is not doubling of the tax burden on businesses that all businesses of all sizes pay. You look at U.S. Department of Labor data, the most recent data, the average Maryland business pays $418 to the UI Trust Fund per employee. That's good for 12th in the country. That's above all of our surrounding states. So we still seem to be paying a much higher contribution to the trust fund as employers than other surrounding states, but yet, the trust fund's still insolvent. We need more money. There have to be other options other than just simply doubling the tax. So I think that the conversation still needs to continue, but that is the primary concern. So I'll conclude there. I'm happy to take questions. Thank you.
Thank you. Good afternoon, Mr. Chair and honorable committee members. I am still Sarah Price on behalf of the Maryland Retailers Alliance. I do first want to thank the sponsor for for reaching out so much during the interim to make sure that we understood what she wanted to implement, trying to get feedback from us. I'm sorry that we still ended up on different sides of the table here, but we greatly appreciate the effort. Our biggest concern, I think, in a broad sense, is trying to reconcile addressing solvency and increasing the benefit in the same bill. We know that increasing the benefit does not result in people getting into a new position faster. So it sort of seems like those two goals are at odds with one another to be increasing the cost for businesses to try to address the solvency, but we are also increasing theoretically the payout for the individuals who are utilizing that benefit. And totally transparent, I've been on it before. It's very helpful. Not trying to say that we don't need UI, but those two goals do seem to be at odds. And our membership does actually have a lot of concerns about the ghosting issue that Delegate Weigel brought up. We do have some concerns about the fact that we don't really know what level of fraud exists currently impacting the solvency, though we do have another bill to try to address that. So I know that's an issue for another time, but that is an existing issue. Thank you.
Good afternoon, Bill George with the Maryland Municipal League, here in opposition to House Bill 205. Prior panelists have talked a little bit about the increasing of the taxable wage base and wage rate. I'm going to talk about the increase in the payments and how that impacts local governments as employers. So most local governments, at least in the municipal world, are reimbursing employers. They don't pay the tax on the front end, they reimburse the trust fund on the back end when a former employee has a successful claim. And so if, this works out in our world, due to a stable workforce, low turnover of employees, it's a better cost benefit analysis for municipal governments as employers than paying the tax rate on the front end. So when we see the increase in the UI payout, while it does seem like it is something that's needed, it's a stark number when you see it's a dollar for dollar increase for what municipal governments will paying as reimbursements to the trust fund. So I just want to fill you in on that side from the employer's perspective, not necessarily from the wage base, but from the reimbursement perspective. This is a huge hit as well. And happy to continue the conversation. Obviously, this is a big topic, but ask for an unfavorable on the bill as written. Thank you.
Good afternoon, Mr. Vice Chair, members of the House Economic Matters Committee. For the record, my name is Mike O'Halloran here today on behalf of NFIB. I want to echo the points made by Ms. Price and Mr. Griffin. From a small business perspective, small businesses who during the pandemic, and I know the sponsor had talked about that, how we were forced to put $1 billion in federal aid to shore up that trust fund. But there were also unprecedented layoffs, government required shutdowns of businesses, so forcing the trust fund to draw down at a historic rate. So when we look at this bill, particularly through the lens of, speaking of historically low unemployment here in the state of Maryland, in fact, throughout the entire nation, and we look at this and we see this bill as, if we want to have the conversation about making changes to how much money comes in, when it comes in, how it comes into the trust fund, okay. But to echo the point, I believe, from the chamber is seeing that money come in at the same time as it going out, the rate at which it goes out is also being increased. Causes a concern, again, all through the lens of looking at historic unemployment. You know, our small businesses are looking to hire, they're wanting to hire. And you know, frankly, the concern is that raising the maximum payout per week could in fact act as a disincentive. And I also do want to echo other comments, appreciate the sponsor for reaching out to us, including us in this conversation, albeit, you know, we remain steadily opposed to the bill, but we do want to be cognizant of that fact and appreciate that. Thank you so much.
Mr. Chair, esteemed committee, Brianna January with the Maryland Association of Counties in respectful opposition to HB 205. And I thank my colleague from MML for walking us through some of the mechanics as local governments. Committee, county concerns come down to the simple math under the bill. Under HB 205, the weekly minimum benefits would increase more than fivefold, and the weekly maximum benefits would more than double. This is a substantial challenge for counties, given our current financial precarious situation, and especially as we look to implement paid leave under the Time to Care Act. So with those considerations, MACO urges a respectful and favorable report. Thank you.
All right. Seeing no questions, Mike, when you come up here, man, those microphones are permanent. We need them for everybody. So if you could try not to break them next time.
I'll try not to.
Thank
you.
you.
And by the way, happy pitchers and catchers reporting day to those who celebrate, especially my fellow Nats fan over there, Delegate Fletcher Harrison. So thank you for the opportunity.
All right. So now, well, that concludes this panel. I appreciate the 4 text messages about our favorite secretary. I did not forget her. For those of you not aware, it goes favorable, unfavorable information. You guys are good. You guys can leave. So with that, we have Alexis Braun, and on Valentine's Day, our favorite secretary, Department of Labor, Portia Will. Quick question for you guys. Do you have a phone up there or something with a calculator? Because I have a technical question I want to ask.
We do have calculators.
All right, cool. Go ahead, whenever you're ready.
Well, thank you. Thank you. Happy to be here. And of course, on Valentine's Day, delighted to be in the wonderful love fest that is this committee. So thank you. Thank you for, I have prepared testimony. I'm Portia Wu on behalf of Maryland Department of Labor, joined by Alexis Braun, our policy director for UI. A lot of points have been covered, so I'm actually just going to try to address a couple of the questions and issues that have been raised. I do want to underscore, even though we're here on an informational basis, we're very grateful for Delegate Charkoudian's leadership. We absolutely agree that there are reforms needed to UI. We are overdue for updates. Benefit levels were last adjusted in 2010. Our taxable wage base has remained the same since 1992. We've got the 17th lowest set of benefits, but the 7th highest cost of living in the country. During the pandemic, contributions for most employers, so the majority of employers are paying at sort of that lowest rate within each table, went from table A to F, or from $25.50 per head to $187 per employee per year. And if it were not for that infusion of funds that Delegate Charkoudian mentioned, we would still be in table F. So I think we can't underscore enough how much that infusion really masked the underlying weakness that was in the trust fund. We've been below 1 for the average high cost multiple. And I know people say, well, what does that matter? It does mean that we can't borrow interest-free from the government. And under the law, federal law, if we need to borrow with interest, that money cannot come out of the fund. So you have to make other special assessments, essentially, or use general revenue to pay for it. So that's one reason it's important to have that buffer and that ability to draw on those federal funds for the state's financial security. I do also want to underscore that the system is heavily regressive. So take 2 companies, Portia and Alexis. I have a worker who makes $10,000. Alexis has a worker who makes $100,000. We pay the same tax if we're like the majority of employers, $25.50 a year right now on Schedule A. But if my worker gets laid off who is making $10,000 a year, they will only get $105 a week. Alexis's worker will get $430 a week. So in thinking about reforms for the committee, I think this is one reason that thinking about how the taxable wage base is expanded and how benefits are adjusted is really important, because right now, a lot of smaller businesses with more part-time workers are paying the same as the giant tech companies or, biomed companies are, but their workers are getting a much smaller benefit from the trust fund. Labor believes any approach should be transparent, equitable, and predictable. We also think rules should be simplified where possible. This is a complex enough program as it is. And then finally, we urge legislators to think about not only the resources to administer the program to make it effective in terms of delivering benefits, make sure it's adequate for workers to support local economies and also less volatile for businesses, but also we need to administer a secure and efficient and responsive system. Federal administrative funding for UI has been declining for years. Given the level of fraud and IT complexity that we need to address right now, frankly, the administrative stream just isn't adequate. We were able to patch that again through the pandemic through additional federal resources, but those are gone. So we need to find a long-term way to address those resources and make sure we can continue to combat fraud and have a secure and transparent and frankly, a much more responsive system. Thank you. Happy to answer any questions.
All right, I do have a question about AHCM, right? And that's just simply money as a ratio of what you need to pay out in the worst possible situation, or I guess as like unemployment or the labor participation rate falls or unemployment rises, correct?
Right. I mean, roughly speaking, average high cost multiple means if it's 1, we've got enough money to pay out about a year of benefits.
Right.
If it's 0.5, we got about enough for 6 months.
And that seems to be the benchmark to describing solvency, correct?
It is. It
Okay.
is.
All right. So that is a ratio. The denominator then is how bad it could be. And it's dictated by the federal government. And that number right now is 1.17. And that's the average over the recent 3 years.
I'm not sure. We use two different numbers. One is our trust fund, the balance that's in the trust fund. And I don't want to turn around and look at Mary's right now, but that is a different number than the HCM. I believe the last reported HCM is 0.92, but that was reported for the 2023
Right,
report.
right. And I'm trying to get to the 0.92, right? So the denominator to get to 0.92, I think the number that we use is 1.17 dictated by it's based on a recession, and that was dictated by the feds. I believe that's the number that we're using as the denominator.
The feds, they look back over several years
Yep.
of recessions, and so they give us the number. We haven't
Correct.
gotten the most recent average high cost multiplier. We think it probably is over 1 right now, but we don't have the exact number yet.
I think we're talking about two different things here, right? But I'm pretty sure when you look back over that time period, right? I think the number that they're giving us, at least last year, was 1.17. I may be mistaken by that, but if I go back through history, that number is actually coming down. It was 1.69, then it was 1.46, now it's 1.17, making it essentially easier in the bad times. I think that's what that number is saying. But the top number, the numerator, is your end year balance divided by total wages. So you take end year balance divided by total wages, that gives you a number, and then you divide that by the number dictated by the feds on how bad it could be over however many years. I think it's the most recent 3 years. So if I use the numbers that I've had multiple people walk me through, right? We do not have the 2023 numbers yet. That'll be out in 2 weeks, give or take.
Usually it's March. Yes.
Yeah, so we'll say a month, we should have those. But if I go back through history and I look at generally the average on how much wages have raised, your total wages have raised, it's been on average about 5%. So if we use last year's, which is about 1.36 billion, then you're going to come out with a number that's going to be right around $143,680 billion. And you take the trust fund balance, which is 1.88 billion, and divide it by that, and you come up with 1.31. And if you divide 1.31 by the 1.17, you get 1.12. And that is what I think we're going to compare to the 0.92 number. So it is significantly above the 1. Like if we're using our AHCM and we want it to be a 1, right now I have it at projected to be at 1.12. There's going to be flexibility within there. It could be more, it could be less. Let's just say it's less, but it's going to be above 1. If I go back through history in Maryland, all the way back to 1990, we have been above one once in our entire history. And that is in 96. So like, I'm not really sure when we start talking about how there's some sort of solvency crisis. I've struggled to see where that is just based on historical data. And granted, it's one flashpoint, but it's the flashpoint we're using from the previous year to make some of these policy decisions, how that there's a crisis. And I'm just curious, if you come up with, I mean, I'm not trying to put you on the spot, but if somebody could get back to me within the office on if I'm way off here, but it seems like to me, we're above one for the first time in 33 years. I'm not necessarily sure the argument around solvency is the strongest argument. Totally get weekly benefit amount. I get that there's a policy decision there, but around solvency, I'm not necessarily sure that we have this solvency issue.
Mr. Vice Chair, I think it would be helpful. We have requested, and actually the Federal Department of Labor is assisting us with sort of updating the model, because we recognize, part of this issue is that it's not just where we are today. It's projecting where things are going to go in the future. You're absolutely right. We're in a better situation than we have been in many years because of that giant infusion of cash. But I think we also recognize economies go up and down. The projections by Upjohn do show us getting into bad shape, but it didn't have all of this information. It didn't have, the big infusion of cash. It didn't have the abnormally low unemployment rate that we're seeing right now. So there are a lot of other factors that are needed to update that calculation. I will say, I think it's likely there is still going to be this problem of long-term lack of solvency if we don't do anything. And that's for a couple reasons. One, our labor force is not growing as quickly as it used to. And that's not just a Maryland thing. It's an aging workforce thing. So in terms of insurance and having your pool, if the number of people in prime working age is starting to decline over time or not growing as quickly as it was, that's a problem for your insurance space. So I think we will have that problem. And I also want to say, even though we, have been below one, my concern also is just the volatility for Maryland businesses, because we have spiked up before in prior recessions. We see that going from A or B to F very suddenly, and that's the counter-cyclical effect Delegate Charkoudian expressed. It's hitting businesses when they're down. It's when they're having the worst economic time, and then suddenly you're getting hit with this big additional tax bill. I think it would be great if the committee could find a way to address that now in better economic times, smooth it out so it will be, less volatile and less difficult for employers.
Yeah, I agree. I mean, that's a component of the bill of drop it down 2 tables at any one time. And obviously, I think that provides a lot more predictability. Additionally, I kind of agree, just tax structure wise, we should probably pay the most in good times and the least in bad times. So that way, when everybody is struggling, we're not hitting businesses the hardest. Okay, Delegate Adams.
Thank you, Chair. So, Vice Chair was asking the question and answered it as I was going to ask you about the balance in the UI Trust Fund. And, we've had, I've been in the committee for 10 years, and we've on occasion had UI come in and talk about the program. Here's our history. Here's what's going on. Here are the concerns if you get too low in the balance. So it kind of goes back to my question of the sponsor of the bill, which is I worry that maybe this isn't a income or a revenue, and I'll call it revenue for the sake of just easily describing it, the money that goes into the U.S. Trust Fund. My worry is, are we using unemployment insurance for reasons that aren't necessarily what it's there for? So the question, and you may disagree with that, and I'd be interested in your opinion, but I almost feel like we need to take COVID out of whatever it is we're doing as far as projections. That happened to our state when we went from A to F and everything that was going on literally has to be removed from that was not normal times. And I would ask you whether you agree with that. And then the follow-up question would be, if you do agree with the idea that COVID shouldn't necessarily dictate future decisions, how would we take what the Vice Chair just said and be policymakers that are being thoughtful about the opposition testimony, which is any business owner that's looking at this tax being doubled, that's going to be a imposition at best. It's going to be a burden at more likely and at worst. So I hope I asked the question in a way you were able to take what I'm doing and yeah.
I think I understand, Delegate. I agree with you about COVID being something of an anomaly, but actually, to underscore what the Delegate Charkoudian said, actually we're better off trust fund wise than we were pre-COVID because of the extraordinary amount of federal funding that we got to use and that Governor Hogan dedicated to this with the separate federal programs off to the side. In prior recessions, we have found the same problem. I think I'm right. I'm looking at the UIT. We have gone from A to F in other recessions before. So that's actually not that unusual, unfortunately. And the numbers I gave are for the people at the lowest tax table. For employers that have a lot of layoffs, like they could be much higher. And so that I think is the concern, is that is not an atypical experience to have employers kind of whipsawed in that situation, unfortunately. And it's in part because we have kept our funding sort of at this sort of bare maintenance level, and what requires so that means when there's small changes in the economy or bigger shocks, the increases in the taxes can be very dramatic.
Well, the table F conversation, I mean, I'd have to go back in time in 2008. Okay, so this was the mortgage-backed security crisis, and there was stress in our state. We could tell it because I can see the budgets at the time, how we were taking general fund dollars to do things that we really shouldn't be doing. The last recession before that would be like 2000, the dot-com bubble. I'm just saying, in history, I'm sure you can say in Maryland, we've had these experiences where there's been an imposition on these tables, but it doesn't happen every other year. It may happen once a decade. And really, if we're talking about recessions and economic stress that puts us from table A to F, in the whole scheme of things, that's not the biggest problem for a small business owner. What I think is really happening, and I talked about it with the bill sponsor, is this rubber band effect that's happening. Hiring people is super tough. Unemployment insurance, if we don't get this policy right, makes it even tougher. But let me try to sum up my last question, because I appreciate what you're saying, and it's consistent with what I've heard in years past, which is that the federal government has helped. It's actually helped our state in many different ways, like not just UI Trust Fund. So I'm happy to hear that we not only took the money and put it where it belongs for the purpose of looking forward, not just spending it while we got it. So I'm happy to hear that testimony. But do we really think that we need to do something this year that's dramatic? I could see tweaking, I could see maybe adjusting, but some of this is dramatic policy change that is going to hit the small business owner. I'm just curious about the timing of it all. Is it really necessary right now?
Well, I think, to the point of better always to do these things in strong economic times than weak ones. So we are in a very strong place. Claims are unemployment insurance claims are about where they were in pre-pandemic days, but certainly unemployment generally is much lower. So I think it's, having as much time as possible to address these issues before they become dire. I mean, we're fortunate to be in this situation of not having a crisis tomorrow, but given the modeling, and we will, I should have finished my thought earlier. Once we get that information from Department of Labor, of course, we commit to sharing with the sponsor and the committee updated modeling. Hopefully, we're trying to sort of bring it in-house so we can run queries directly ourselves more quickly for you. So if you have different scenarios you want us to look at, we can provide that. We weren't able to get that before this hearing, unfortunately, but we are trying to get it as quickly as possible.
Thank you, sir.
Would you mind responding to my earlier question about how the department validates active job searches given the online platforms that are out there?
Of course. So, individuals have to attest and you have to regularly update your work search activities. Unemployment insurance does conduct some audits, but sort of at a very small scale. I think what's challenging, I agree, we all want to make sure work search activities are real. And we also have requirements where we, identify certain individuals that might be at risk of continuing on unemployment long-term. And we require them to engage in certain reemployment workshops and other activities. And we check that and require, those are run by our American Job Centers and our locals. And we check that and make sure people do it. I think we're very open. I understand there might be legislation to try to study this further, because part of the difficulty is, as Delegate Charkoudian said, we can't tell, we only see, if someone ghosts an interview or doesn't show up to something. I've had that happen myself, where someone doesn't call back or doesn't show up. We don't know that that doesn't mean they didn't get other work or they weren't looking in some other way. So it's a little challenging. I think we want to delve into it more deeply. Alexis, am I missing anything on our activities?
No, I think we're open to ideas. We want people to be doing the reemployment activities that they claim to be doing as well and checking it. And but I think it becomes a problem. The example that you provided of a sort of information coming into us just every, if someone doesn't show up for an interview, my understanding is that employers wouldn't know if that person is a UI claimant or not. So we have an issue of being able to match them up to a person in the system. And we would need information such as socials to be able to be sure that we're, attaching an issue to the correct individual. And I'm not sure that at the stage that we're talking about some of the ghosting examples, that information would be available to the employers to provide to us.
Yeah, I get that, but you are the experts and, I'm not talking about a one-off where somebody just doesn't show up. It was 100% no-show on a job that we had advertised on these online. And so I just stopped using them because it was just a total waste of my time. And so it's not just a random thing where somebody, must have gotten a job and just didn't bother. And I actually call them back and say, look, you didn't show up. And of course, you never get a response or anything else either. So I'm just wondering if the system's being taken advantage of.
I mean, it's always a concern. I think, as Alexa said, it's hard for us to validate and match with the person if we don't get a lot of PII. And I'm not sure the employer would have that and be able to say, this is who it is. I have their social security number. You can match them to a record. And even then we'd have to do a whole inquiry to ask, okay, did you look for other work? But absolutely, I think there's this broader question of like, how can we make sure that employers aren't having their time and resources wasted by trying to recruit individuals on various platforms? How can we, have a more robust and better job search process from the rest of our department's work? We are really invested in making sure that happens because we want to fill those vacancies and we want people to be able to grow their businesses.
Yeah, I mean, you seem to question not even knowing that they're on unemployment, but I can't imagine why anyone would do that if it's not for an unemployment claim. Why would someone just out of pure entertainment send a resume to an employer and then just not show up for interview, other than if it were for active employment to satisfy the unemployment?
Right. And I think the secretary's point to that, and you agreed with that too, is true, but that wouldn't account for your 100% rate at that time that you were saying. But I think we have an issue with how we would be able to match that up with real people and real claimants. And that's just something in the study bill, if it moves, we can look into things like that. But that example is hard for us, given that we don't know who people are at the stage that they're ghosting employers.
Okay, thank you.
All right. Thank you so much. Happy Valentine's Day. That concludes this bill hearing. And the bill hearing should